All jurors are present and accounted for, Your Honor, ma'am. Please be seated.
Welcome back. We already have our witness here. Did you call out the name of your witness so the jurors know who's coming in?
They will call Rachel Stiles to the stand.
Okay. All right. We'll get more on point as we move along here. This is Ms. Stiles. Welcome back, jurors, from your lunch break. We went a little bit later. We were working on some other things. Thank you for your patience.
Yes. Ma'am, raise your right hand. Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, ma'am, if you will. Please have a seat. Get as close to the mic as you can. For the purposes of the court's record, please state and spell your name.
Rachel Stiles, Rachelstyles.
Hey, good afternoon, Ms. Stiles. Could you introduce yourself to the jury and let them know how you're currently employed?
My name is Rachel Stiles, and I am currently retired.
Now that you're lucky enough to be retired, can you tell the jury what you did prior to retirement?
Well, for 25 years, I was the house manager of the Omni Coliseum. I worked as executive secretary for Mr. Ted Turner at the Atlanta Braves. And I worked at Corey Company for what was supposed to be 4 months. It ended up being 4 years. And I've done numerous event planning and things like that.
And how did you know Diane McIver?
Yes, I did.
And how did you meet Diane McIver?
I was invited to their company annual picnic, and I see this lady running around dressed very neatly and wearing a hat, and it was definitely obvious that she was in control. So I asked to meet her.
And do you remember about, I guess, the year that would have occurred?
It was probably somewhere in the late, probably 70s, early 80s.
And from then on, did you and Miss McIver form a friendship or a relationship?
Very much so.
Okay. And tell the jury how that relationship evolved.
Well, you know, once Diane and I met, it was just an instant friendship. And when Diana needed something done, she would call me, whether it was planning a party or assisting her with things. And then later on, I did work with her at Corey at her company.
And through, I guess, the planning of parties and other various work activities you did with her, did you form a strong friendship with her?
Yes.
Okay. And did that friendship continue until her passing on September 25th of 2016?
Yes.
Now, you said you planned parties for her. Did you happen to, were you involved with the planning of her wedding?
Very much so.
Okay. And how did you get involved with that?
Well, Diane calls me in, and you know, I had done quite a few things, parties for her, and you know, the ultimate compliment was, in trust, was that, would you do Tex and I's wedding? And I was very honored to do it.
Okay. And what year was their wedding?
It was November the 5th, 2005.
Okay. And when did the planning start for that big event?
We started a year ahead of time.
Okay. And what went into, well, I'll ask a better question. Have you been to the ranch?
Oh, many times.
Okay. And had you gone to the ranch prior to the wedding in November of 2005?
Yes, sir.
Okay. And for the wedding, were renovations made to the ranch?
A lot.
Okay. Can you describe to the jury some of the renovations that were done to the property?
Well, they built the barn saloon, and we did the pool. We re-landscaped the whole property. So there was a lot going on.
Okay, so was the barn, the pool, and the landscaping, it sounds like you had a part in, was that all done before the wedding in November of 2005?
Yes, sir.
Okay. And were both the defendant and Ms. McIver involved in the planning of the wedding?
Absolutely.
Okay. And did the wedding go off without a hitch?
Yes, except when the carriage came in with Diane and the mayor saw the other horses, it was almost dumped Diane out of the carriage, but that was the only small thing that happened.
Okay. Now, were Mr. McIver's children in attendance to the wedding?
His son was.
Okay. And do you know what his son's name was? Or is? Excuse me.
I just drew a blank, and I can't remember.
Okay. Do you know how many sons he has?
I believe he has two.
And does he have any other children?
I think he has a daughter.
And only one of them came to the wedding?
Right.
Okay. And did you ever, from then on, did you have an opportunity to see the one son who attended the wedding?
No.
Now, do you know Austin Schwab?
Yes, I do.
Okay. How do you know Austin Schwab?
Well, Austin was Diane in Texas' godson.
Okay. And how long, I guess, have you known Austin?
Since he was born.
Okay. And knowing him since he was born, can you describe to the jury Diane's relationship with Austin?
Diane and Tex just worshipped Austin. And he was a child that Diane never really had. So she was quite honored to be his godmother.
Okay. So she loved him, or did she love him very much?
Understatement.
How often through the years do you think that you spent with both Diane and the defendant, Mr. McIver?
It varied.
Okay. In the last, let's say, 5 years, how often do you think you would spend with Mr. and Mrs. McIver?
Quite a bit.
Okay. And did you form a friendship like you had with Ms. McIver with the defendant?
Yes, I did.
Okay. And did you ever work with the defendant?
Yes, I did.
Okay, and what kind of work did you do or work with the defendant?
I was Texas bookkeeper.
Okay, and how many years were you the defendant's bookkeeper?
Probably at least 10
10?
or more.
Okay. Are you still currently his bookkeeper?
I would hope so.
And when you say you were his bookkeeper, can you kind of walk us through or describe what exactly, I guess, you were doing for him?
Well, excuse me, I would collect all of the information that we needed each year for taxes. And periodically, I would help him balance his checkbook.
Okay, and did you, while doing that as well as, I guess, planning the wedding, through that, did you, I guess, gain knowledge or determine how the defendant and Ms. McIver kept their money?
Well, we had a separate account for the wedding, and they also had a construction account.
And I'm sorry, I should have asked a better question. Also, through your tax work, did they keep their finances separate?
Absolutely.
Okay. So Tex paid for his stuff and Diane paid for her stuff?
Correct.
Okay. And throughout the 10 years that you've been doing the bookkeeping or the tax organization for the defendant, has it always been that way?
Yes.
Now, through your friendship and working with Mrs. McIver, did she ever talk to you about her finances?
No.
Okay. Did she ever talk to you about the intimate details of her relationship with her husband, the defendant?
It was quite obvious they were very much in love, and, you know, words didn't have to come out.
Okay. And I appreciate that answer, but my question was, did she ever talk to you about the intimate details of her relationship with the defendant?
No.
Okay. Was Ms. McIver a very private person?
Very much so.
Okay. And she never discussed her private, intimate details of her life with you?
No.
Now, when doing the bookkeeping or the tax organization for the defendant, did you learn that his status or his employment at his law firm, Fisher & Phillips, had changed?
Yes.
Okay. And can you tell the jury how it changed, if you know?
He went from a partner, from a full partner to, I forget the terminology, but he relinquished his pretty much ownership of full partnership with his company, with a law firm.
And I'm going to test your memory. Do you remember when that happened?
I believe it was about 2 to 3 years ago. I can't remember exactly.
And with that, did his income change?
Yes.
And was it a significant change?
It was a gradual change.
Sorry,
So,
could I just object to the characterization of significant and just ask her what the change was?
I'll refer to the question.
okay,
And I think it's your evidence already anyway.
you can ask the question, if you ask it differently.
How did it change?
His work schedule diminished, quite a bit.
Okay.
And on his own, because he wanted to spend more time with Diane.
And from that, how did his income change based on the tax documents that you were analyzing or organizing, excuse me? Do you remember?
Would you repeat that?
How his income changed? Did it get higher? Did it get lower?
It gradually decreased.
Okay.
Not a dramatic decrease, though.
Okay. So in your opinion, not a dramatic decrease?
No.
When was the last time that you did Mr. McIver's taxes?
2016.
Have you been working on 2017 yet?
No.
Now, through your work that you've done, I guess, with Mr. McIver and the time that you've spent with him, is it fair to say that you respect and admire the defendant?
Very much so.
And is it fair to say that that respect and that admiration remains today?
Yes.
And you said you worked at the Corey Company?
That's correct.
And what years, I think you said it started as 4 months and went to 4 years. What years did that span through?
It was September of 2011 to February of 2016.
And while working with Mrs. McIver, did you have an opportunity to attend functions or visit the ranch that they got married at?
Oh, yes.
Okay. And while at the ranch, did you ever have an opportunity to fire firearms or guns?
Yes.
Okay. And how many times would you say that you did that?
Only a couple times.
Okay. And was the defendant there when you fired these firearms?
Yes, sir.
Did you bring your own, or did you use his or theirs?
I brought my own.
Okay. What kind of gun do you have?
I just have a little 32.
Okay. Just a little 32. Where do you keep that little 32?
Right beside my bed.
Remind me not to come over at night.
Better call first.
Yes. Duly noted. Now, when you were at the ranch firing that 32, did you ever fire any other weapons?
Yes.
Okay. Do you remember what kind?
One looked like a cowboy pistol,
Okay.
and the other was sort of a rifle type.
And did Mr. McIver in those instances ever talk about gun safety?
Oh, yes.
Okay, can you tell the jury a little bit about what he said and what you mean by oh yes?
He would say, never point a gun, at someone. Always point the gun down. Make sure that, you grip the gun properly. And just general, cautions, because I was new at handling guns. And so he gave me a lot of instructions about, the safety of the gun and what it entailed.
And did you do that every time that you were there to fire, when you fired firearms at the ranch?
Not as much in detail after the first time.
And Was gun safety something that was very important to him?
Objection I think that would call for speculation unless it's something he said.
Did he tell you that gun safety was very important to him?
I don't think he ever said those words, but his demonstrations illustrated that.
Okay. Now, can you tell the jury how you learned about Ms. McIver's death on September 26th, 2016?
I received a call from Tex a little after 6 o'clock on Monday morning. And his words were, "Rachel, I'm probably going to need some help today. Could you come to the condo?" And I said, "Sure." But I could tell by the tone of his voice that wasn't the real reason. And I said, "What's up, Tex?" And there was a pause. And he said, "Diane is dead." Well, I started screaming because it was just unbelievable.
Okay. And then after he said Diane was dead and you had your reaction, did he say anything else to you?
I just told him I would see him shortly.
How much time lapsed from that conversation on the phone where he told you Diane was dead that you went to the condo?
I think I arrived shortly after 9.
Okay. And that was on Monday the 26th?
Yes, sir.
When you arrived, do you recall or do you remember who else was there?
There were several people there. Danny Joe was there. I think Annie was there. Phyllis was there. I can't remember anybody else.
And when you got there, what was the first thing that you did?
Well, I first, went to Tex, and he gave me a hug and was just crying uncontrollably and could not talk.
And while you were there, did you see the defendant using the telephone frequently?
Yes.
Okay. And did you hear or were you a part of any of those conversations?
No.
Okay. And after you initially consoled the defendant, what did you do in the condo?
I'm still almost in a state of shock myself, so I can't give you exact details, but I did speak with Danny Joe because, I understood that she was there and that she was the one driving the car, and I did speak with her.
Okay. And after speaking with Danny Joe, did you continue to remain at the condo with the defendant?
Yes.
Okay. And throughout the day, did other members of their friends circle show up?
Yes, quite a few.
And do you remember off the top of your head anyone who sticks out in your mind?
There were so many I can't remember what was there.
Okay. And do you leave the condo that day?
I may have left, but I did come back.
Okay. And did you stay the night there?
Yes, I did.
And do you remember, did anybody else stay the night, that first night, Monday the 26th?
Yes.
Who else stayed the night?
I believe Annie and myself.
Okay. And do you remember, I know it's been some time, where did you sleep that evening?
I slept on the sofa in the living room.
Okay. And where did Annie sleep?
I believe she was on the floor in the bedroom,
In which bedroom?
in Tex's bedroom.
Okay. And where was the defendant sleeping?
He was in the bed.
Okay. And you said on the floor, did you physically go in there and see her on the floor?
No.
Okay. And that next morning, Tuesday, the 27th, what do you do when you first wake up?
Well, Tex wakes up first and, as usual, he makes coffee for everybody.
Okay. And is it just the three of you that are still at the condo, or at that point had other people come over that morning?
Phyllis had arrived, and I can't remember if Jamie had come over at that time or not.
And do you remember You said you saw Danny Joe on Monday when you first got there.
Yes.
Was she there on the 27th, the next day?
I believe she had spent the night at Janie's and then did come over for her morning coffee.
Okay. And what did you do next to help with Mrs. McIver's passing that Tuesday morning?
Well, I made a call to the Fulton County Examiner's Office to see when the body would be released so that we could start planning a memorial service.
And from doing that, or as part of that process, did you begin the process of locating a funeral home?
Yes.
Okay. And where was that funeral home or service located?
I spoke with Mr. J. Grover and asked him if he had any suggestions of a funeral home that in Conyers, because I knew that that's where Diane had spent most of her life.
Okay.
And I said, Diane wants to be cremated. And I said, do we have to go through a funeral home?
And, I'm sorry, I interrupted you, you finish.
And he said he had a very good friend that ran a crematory and that, to give her a call.
Okay. And do you remember the name of the crematory, the funeral service? It's okay if you don't.
I believe it's Phoenix.
Okay. And did you call the Phoenix Funeral Services?
Yes, I did.
Okay. And did you begin the process of getting Mrs. McIver's body down to Conyers?
Yes, I had to get release papers from the examiner's office. And then I had to get authorization from the crematory to go down and secure the body.
And how did you know that Mrs. McIver, her wish was to be cremated?
I believe several friends had said that and Tex verified that, and I believe her will, her first will said that.
Okay. And when do you believe that Tex or Mr. McIver told you that? Was it that Monday you first showed up? Was it that Tuesday morning? Do you remember?
I believe it's when they secured a copy of that will.
Okay. And do you remember when that was?
No.
Were you there when that the will that you're referring to was secured?
I don't remember.
Okay. Now, did you, as part of that process, did you have to go to the crematory, the Phoenix Funeral Home in Conyers?
Yes.
And what was the reason that you went there?
Well, Tex, as we all have heard that, some crematories don't always give you the ashes of the individual. And Tex said, would you go and make sure it's Diane?
Okay.
And since I didn't know anything about the crematory, I wanted to make sure that it was a nice place.
Okay. And did it meet your, approval when you got there?
Very much so.
And when you got there, did you receive any of Mrs. McIver's belongings?
I believe there was a bag that Wendy gave me that was a necklace and some earrings maybe that they had, the Fulton County Examiner's Office had presented to her.
Okay. And did you take those back to the condo here in Atlanta?
Yes.
Okay. After getting back to Atlanta to the condo, do you remember, did you stay at the condo again that night? Or did you go home? Do you remember what you did?
I did that Tuesday night also.
Okay. And that Wednesday, what did you do at the condo?
Well, that Tuesday I had to get Tex to sign the releases and I waited all day and finally he signed them. And when he signed them, he said, this is the final thing.
I'm sorry,
This is the final thing.
And when you went down, did you go alone to the crematory?
No, I took a friend,
Who did you take?
Dee Harold.
And that Wednesday, did you have more interaction with the defendant?
I think it was pretty brief on Wednesday,
Okay.
because I had things I had to do.
Okay. So you went home, did you go home that Wednesday?
Yes.
Okay. And after that Wednesday when you went home, when was the next time that you can remember that you had contact with the defendant?
It was probably on Thursday, just briefly.
Okay. Do you remember what the contact was about?
Well, when I went to the crematory, Miss Wendy gave me locks of Diane's hair,
Okay.
and I took those back to Tex.
And at that time, had members of his family arrived?
I believe Dixie had come in. I can't remember exactly. It's, as I say, the whole thing was quite a shock for me too. So my memory was not at the best at that time.
I understand. And Dixie, is that Tex's sister?
Yes, it is.
Okay. And had you met her before?
Yes, I had.
Okay. And do you remember how many times was it?
I had seen her of course, at the wedding. We spent quite a bit of time that week of the wedding. And I believe I've seen her at a Texas birthday party or something.
Okay. And when, based on your recollection, when do you believe is the last time, or when was the last time that you spoke to Diane before her passing?
It was that Friday morning, and she was, after she got to the office, because we were scheduled to exchange her clothing that following Friday.
Okay.
And she was just reminding me to make sure I had that on my calendar.
Okay. Another one, was that another one of your job duties?
Yes, twice a year.
All right, now explain to the jury what went into this twice a year, I guess, exchange of clothing.
Well, her winter clothes would be stored away, and we would bring those in, and then change out the summer clothes. And that was the hats, the purses, the shoes, and the clothing.
Was it a pretty big ordeal?
Quite an ordeal.
Okay, did she have a big, beautiful closet?
Oh, yes.
Okay. And through, how many times do you think, or how many years have you been helping her with this twice a year exchange?
Well, the first couple of years, there were several people, and then they couldn't come one year, and it just, she and I, and we accomplished it in a much lesser time. So I became the only one for the last, except for, James brought the closing up. But she and I, because we got so used to what went where, that she just said, well, you know how to do the hats. You know where my shoes go.
All right. Is his organization a strong suit of yours?
I would hope so.
Yes. Okay. And did she ever show you, or did you know where the safe was in her closet?
No.
Okay. So through the multiple years and the twice a year time that you did it, you never saw the safe in there?
No.
Okay. Now, let's talk a little bit about your work with Ms. McIver over the last 4 years at a quarry company. Why were you brought in to U.S. Enterprises or the quarry company by Ms. McIver?
The receptionist was going to have back surgery, and Diane called and asked me if I could come in and help them out for about a month while she recovered from her surgery.
But it sounds like it was in fact not a month.
No.
It was, I believe you told the jury, 4 years?
It was close to it, yes.
Okay. And during those 4 years, what were some of your main job responsibilities and duties?
Well, I was a reception. I answered the phone, I greeted the guests, I bought the office supplies, I helped quite a bit in accounting, processing contracts, reorganizing the filing system. I could go on and on.
Right. So it sounds like you did it all.
I was, very energetic and wanted to do the best I could.
Okay. And did you work closely with Miss Diane through those years?
I saw her every day.
Okay. And during those years, did you at one point have a conversation or about her will?
Yes.
Okay. And can you tell the jury about the time period or the years that you believe that occurred?
I would say it was somewhere latter part of 14, early 15.
Okay.
It
So,
wasn't a significant event, so I didn't make a note of it.
okay, so it was 2014, the latter part of 2014 or into 2015.
About that time,
Okay.
yes, sir.
And how did that conversation, or could you tell the jury how that conversation came about?
Just for the record, I would need my objection.
Okay, that's noted and preserved.
May I proceed, Judge?
You may.
You can answer the question. Let me ask it again.
Yes, please.
I know I talk fast sometimes. Tell the jury how that conversation about her will came about.
She called me in her office and said, I need you to make some copies of these papers. She said, I cannot trust anyone else. So I proceeded to the copy room and I made the copies and I went back and handed them to her and she says, thank you so much. This is my new will.
Now, about what time of the day do you think that she asked you to make those copies was?
It was probably around lunchtime because there were a lot of people out of the office at that time,
Okay,
on
so-
lunch break.
A lot of people were on break.
Right.
When she approached you, or tell us, did she approach you or did you go into her office when she first asked you to make the copies?
I think she just stuck her head out the door and said, I need you to make some copies for me.
Okay. And after she did that, did you go into her office and retrieve
Yes.
the pages?
Yes.
Okay. And when you were making the copies, or before you made the copies, did you look through or the document that you were copying?
Absolutely not.
Now, and tell the jury why you didn't look through it.
Well, when Diane said she could only trust me, there was no way I was going to betray her trust. So I would not dare look at anything that she did not want me to be a privilege of.
And on that note, let's get some water. On that note, is there any other reason why you didn't look at the documents you were copying?
Well, I had previously copied some copies for her, and they were in reference to the possible sale of the billboard company.
And if she would have, I guess, walked into the copy room and you were looking at the documents, tell the jury what would have happened.
Well, she would have probably exploded.
Okay. Did you know her to have a sharp tongue?
Quite a bit.
Okay. Tell the jury a little bit about Miss McIver's sharp tongue.
Well, there were several times that, she would get on me, but I knew that was just Diane's personality. And one minute she could be chewing me out, the next minute she's hugging my neck and telling me how much she loves me.
Okay. So once she got it out, it was done. Okay. And so after you made, you remember how many copies of the document that you made?
It was more than 2 and less than 10. I don't remember, I didn't count them.
Okay. And you remember how many pages the document was?
I just said,
Oh. Okay, so let me ask, I'll
I
re-ask.
don't know the exact number of pages.
Okay, but how many copies of the actual document?
Oh, I made 2 copies.
Okay,
I'm sorry.
2 copies that you believe that it was more than 2 pages, but around 10 or less than 10.
Less than 10.
Okay. And once you made those copies, did you go back into her office?
Yes,
And did you directly hand them to her?
yes,
Okay. And when you were handing them to her, were you about as close as you and I are now?
yes,
Okay. And is that when she made the comment, thank you, you just made a copy of my new will?
yes.
Okay. And when you heard her, was it just the 2 of you in the room together?
Yes,
And she was speaking clearly when she said it to you?
yes.
Okay. And after she said that to you, did that make you think twice? Did you think anything of it?
No.
And why not?
Well, I knew she loved Austin. And, you know, Austin wasn't born when she did her initial will. So I just felt that she was making changes because she wanted to make sure he was in there.
Okay. And after she told you you were just make copies of her new will, did you just leave the office?
Yes,
Okay. Get back to work?
yes,
Okay, because you were on the clock?
yes.
Okay. And, now, do you know today where that new will that you copied back in 2014-15 from Ms. McIver is today?
Objection. I think that would call for speculation.
Well, she should answer yes or no, and then we could work through.
If she says no, I will.
Well, you need to establish how she would know that, so it could be speculation, it's hearsay as well, depending on how the styles learn that. So why don't you ask other preparatory questions if you want to explore it.
Okay, yes, Your Honor. After making those copies for Mrs. McIver back in 14-15, did you ever see that new will again?
No,
Okay. And after she died, did you ever see it again?
no.
Now, just to back up, I have a few more questions and I apologize. When you first initially spoke to Mr. McIver after you got to the condo and Mrs. McIver had died, do you remember what the defendant told you about calling ahead to Emory?
I'm sorry, I didn't hear your question, the last part of your question.
About calling to Emory, alerting that Mrs. McIver had been shot?
I believe that, I can't remember, Diane, if Danny Jones said that they had called ahead or a text had said, I can't remember exactly.
What-
So, Your Honor, I guess I would object then to her question, since she can't remember what she heard. It may have been hearsay, and I would ask to strike it and ask the jury to disregard it.
Okay, so it's not so much the question as the objective, to understand your concern. Based on that answer, you can continue to explore this area, but the jurors should disregard an unattributable statement.
Yes. And Ms. Stiles was looking at a copy of your, a transcript from a recorded interview, possibly help refresh your recollection.
Possibly.
Okay. I'm going to show you, I'm going to direct you to page 107. And if you will just look at the bottom and see if that helps refresh your recollection. Does that help refresh your recollection?
Maybe.
Okay. Well, I got to get a yes or a no.
No.
Okay. So, if you don't remember Mr. McIver telling you that after he shot Diane, that he called ahead to Emory to alert them that she would need surgery?
I object to the question based on her answers and the fact she said her memory was not refreshed.
I think we covered it, and she said she doesn't remember, and you showed her a transcript, and it wasn't maybe, it was no, that doesn't refresh my recollection.
Well, okay, I will ask a follow-up question if Your Honor doesn't mind.
So far, so good.
Okay. Now, do you remember speaking to Mr. Rucker, as well as the investigator at the time, Investigator Terry Jackson, at I think it was a Chick-fil-A or a restaurant?
Yes.
Okay. And do you remember about when that was?
I've spoken to you guys so many times I don't remember.
I'm sure you're tired of seeing us, right?
Glad to go home.
You remember meeting with Mr. Rucker and Investigator Jackson?
Yes.
Okay. And you remember talking about this incident, or we're talking about what you knew about this incident and your relationship with both the defendant and Mrs. McIver?
Your Honor, Mr. Abadi, could I ask you a question, make sure I'm on the same page with the transcript as you? Since I have a different.
Now, do you remember talking to me out in the hallway, I guess earlier today?
Yes,
Okay. And do you remember us talking about a statement about the call ahead to Emory?
yes,
Okay. And do you remember telling me that Tex was the one who told you that?
yes,
Also, while you were at the condo, do you remember asking or talking to Mr. McIver about him drinking the night of the incident?
I think they had had a glass of wine at the restaurant.
Okay. And is that what he told you?
I believe so, yes.
Nothing further at this time, Your Honor.
Ms. Clark Palmer, questions for Ms. Stiles? Who is ready to go home?
She is not the only one.
Ms. Stiles, I want to, good afternoon.
Thank you. Good afternoon to you.
I want to start where we just finished and work backwards. So you just told Mr. Abadi that you remember talking to him today and telling him today that Tex told you that they called ahead to Emory and let them know something about surgery was going to be needed.
I believe he just said that, they called ahead.
Okay.
I don't remember the contents of it.
I want to show you, I would like for you to look at well, here's my question. Is your memory that Tex told you that right after the incident happened? Or is it that you heard it? You heard from somewhere that Tex had said they called ahead?
I believe I just heard it.
Okay.
I don't believe Tex told me directly.
Okay, so just so it's really clear for this jury, your basis for saying that Tex called ahead to Emory after Diane had been shot is based on something that somebody else told you, right? It's not based on something that Tex McIver told you.
I don't remember Tex telling me directly.
Okay. You can't remember where you heard that from?
No.
Okay. Okay, so now let me ask you about 2014, 2015 when you were working at Corey with Diane, okay?
Okay.
All right, and you've told us about this document. You can't remember how many pages it is exactly, right?
No.
You didn't know you were going to be tested on it 3 or 4 years later,
No.
right? You didn't look at the paper, correct?
No.
Don't even know if there was anything typed on the paper or if it was handwritten, correct?
No.
Okay, I could keep going. You don't know if it was signed anywhere by Diane, correct?
No.
Okay. And at the time you made these copies, the U.S. Enterprises was in negotiations to sell one of their companies. Is that right?
Correct.
Okay. And if they sold that company, it may put some people at U.S. Enterprises out of a job, correct?
Correct.
Okay. And they were trying to keep information about the negotiations kind of quiet, correct?
Correct.
They didn't want people to leave while the negotiations were going on.
Correct.
Okay. And Diane told you, when she asked you to make copies of this document, she said, I can't trust anybody else, right?
Correct.
And at the time she asked you to make these copies, you know who Billy Corey is, right?
Yes.
He owned U.S. Enterprises at that time, right?
Correct.
He had an office in the building at that time, right?
Yes.
You know who, and Mr. Corey, you know who I'm talking about sitting back in the courtroom, correct?
Yes.
Okay, you know him, right?
Yes.
You know Jay Grover, right?
Yes.
And he worked for Mr. Corey at the time that Diane told you I can't trust anybody else with this document, correct?
Correct.
You know Angie Brooks?
Yes.
She worked at U.S. Enterprises at the time that Diane said I can't trust anybody else with this document.
Yes.
You know Ken Rickert?
Yes.
Ken Rickert is a lawyer.
Yes.
He was the lawyer at U.S. Enterprises at the time that you made a copy of this document?
Yes,
And he worked there at the time Diane told you she couldn't trust anybody else with this document, correct?
correct.
All right, so, okay, let me now move back to where we kind of started your direct testimony, talking about Tex and Diane. You told us that you've known Diane for a very long time.
Correct.
You've known Tex for a long time.
Yes,
And you not only took a year to plan their wedding, but you met with Diane every week for that year to plan their wedding, correct?
yes, every Monday night.
Okay. Did I hear you say that there was a wedding bank account?
Yes, ma'am.
And that was an account that they both contributed money to
I believe so, yes.
pay for various wedding expenses?
Right.
All right. Because the wedding was expensive.
It was nice.
Okay. It was more than 6 figures, wasn't it?
About that,
Okay. There were a lot of people who attended.
yes.
All right. And then you said, did I also hear you say that there was a construction account?
Yes,
And that account was used to make improvements on the ranch?
it was to build the barn and the saloon.
And the barn and the saloon were built before the wedding?
Correct.
And that was an account that they both contributed money to?
I believe so.
All right. And you saw Diane's clothes and purses and hats and jewelry, right?
Touched them twice a year for many years.
Fair to say she liked to spend money.
Yes,
Also fair to say Tex was more conservative with his money, correct?
yes,
Okay. You never saw Tex and Diane argue about money,
never.
okay? You knew Diane before she met Tex.
Yes.
It's fair to say that she changed when she met Tex.
Diane, for once, became a very happy person.
For once, she became a very happy person, is that what you said?
Yes,
When she met Tex. Right?
correct.
Because she was crazy about him.
They loved each other dearly.
They loved each other dearly for the entire time that you knew the two of them?
Absolutely.
All right. And he always called her darling, didn't he?
That's correct.
Okay. Is it fair to say they were like two teenagers in love?
All the time.
Okay. Is that your words? Is that how you've described them before? As two teenagers in love?
I'm not sure I use those exact terms.
Okay.
but,
How would you describe it?
I mean, they just complimented each other. It's when Tex came into Diane's life, it was like, she had a partner for the first time. And they shared everything together.
Now, you told us about some of the other things that you did before you went to work for U.S. Enterprises or Corey. But you are also, you're also a registered nurse, or were a registered nurse.
Yes.
What's correct? You are a registered nurse, or you were a registered nurse?
I was.
Okay. And you told us about when you were at the condo after Diane died. And you know who Dr. Hoos is, correct?
Correct.
And who is he?
He's Texas doctor.
All right. And you know Dr. Hoos too?
Yes.
And he was at the condo in those first few days after Diane died?
Yes.
All right. And you told us that you spent the night at the condo.
Correct.
Okay. And you saw in those first few days that you stayed at the condo, you observed Tex and you observed his demeanor in those days, correct?
Yes, ma'am.
Did you see him cry?
Yes.
How would you describe the crying? I mean, are we talking about just a tear here and there?
When I arrived, and I gave him a hug, and he was just crying uncontrollable, couldn't even speak.
Was he like that over the days and nights that you stayed?
I don't remember that type of crime, but he spent a lot of time in his bedroom and alone, and several times when I would go in to check on him, he would be sobbing.
And you knew that he had been prescribed medication at that time, correct?
Yes,
Xanax, right?
I believe that's correct.
Okay. And you spent the night in part to make sure that he was okay, correct?
At the request of Dr. Hughes.
Dr. Hughes asked you to spend the night?
Yes, he did.
Did you actually have Tex's medication?
Yes, I did.
Why did you have it?
Dr. Hughes wanted me to make sure that I had control of it because of the state of mind of Tex. He was afraid that he might take more medication than he should,
And maybe hurt himself?
could.
Okay. And when you were the one who handled dealing with the crematorium, correct?
Yes, ma'am.
And you got the paperwork from Miss Wendy there, right?
That's correct.
And even though you had the paperwork, that was something that Tex had to sign, right?
Yes.
As Diane's husband.
Yes.
And you tried to get him to sign those, and initially he didn't want to sign them, is that right?
It took all day.
To get him to sign the paperwork? And is that because he told you that when I sign these forms, it's over?
Yes.
Okay. And you know that, you know Annie Anderson, correct?
Yes, ma'am.
Okay. And you knew her before September of 2016, right?
Yes, ma'am.
Okay. She was someone that you met through Tex and Diane.
Correct.
And she's good friends with Tex and Diane. They have a business relationship and a friendship, correct?
Correct.
And in fact, Annie is married, isn't she?
Yes, she is.
Okay. And when she got married, where was her reception held?
It was held at the ranch.
At Tex and Diane's ranch?
Tex and Diane's ranch.
Okay. And you know Annie's husband?
I've met him a couple times, yes.
Okay. And you know that he's like a personal trainer?
I believe that's correct.
Okay. And he knows Tex and Diane.
Oh, yes.
He's friends with Tex and Diane as well, correct?
Correct.
Okay. And you told us that you spent the night at Tex and Diane's condo those first 2 nights, correct?
Correct.
And Annie spent the night there as well, correct?
Correct.
And you said she slept in Tex's bedroom, correct?
Correct.
On the floor, correct?
That's what she said.
On like made up a little pallet that she slept on?
I believe so.
Okay. Fair to say she was also concerned about Tex's mental health and well-being?
Yes.
All right. I forgot to ask you a question about the wedding. There was a rehearsal before the wedding, correct?
Yes.
And it was at the ranch too?
Correct.
And was there a video made of the wedding itself?
Yes, it was.
Was there a video made of the wedding rehearsal?
Yes, there was.
Was that done by a professional videographer?
Yes, it was.
Is that someone that you hired?
Diane and I both interviewed him.
Okay. And do you have a copy of the wedding rehearsal and the wedding videos?
Yes, I do.
Okay. Still today you have a copy of those?
Yes, I do.
Had it for all these past years since they've been married?
Yes.
Okay.
Okay,
Thank you.
Mr. Abate.
Just a few, Judge. Now, Ms. Sal, Clark Palmer asked you about Miss Annie Anderson making a pallet and telling you that's where she slept, did she also tell you that she was in the bed giving Mr. McIver, the defendant, a massage, and that's where she slept that night?
No,
Okay. And this bedroom is the same bedroom that the defendant shared with his wife,
correct.
and his wife had only been dead for a few hours.
Correct.
And we talked a little bit about on direct, and then she talked to Miss Clark Palmer talked to you about across about the statement regarding the call to Emory. So you remember telling me outside the hallway before we started your testimony that the defendant had called ahead and told them they had a gunshot wound and that they had a gurney and everything ready and waiting when they got the car to the hospital. You remember telling me that that was true?
I believe that's, yes.
And that's what Tex told you.
I don't know if it was Tex told me or if it was Danny Joe that said that they had called ahead.
Do you remember telling me that Tex is the one who told you that before you came here to testify today?
It might have been in some of our conversations that you said that.
Okay. Now, you talked a little bit about the wedding account. Do you remember how much each party, Ms. McIver and the defendant, put in that account?
Now, all I did was submit invoices and they gave me a check.
And Ms. Stiles, I'm going to show you what's been marked as State's Exhibit 440. If you'll look at it and just read over it and tell me if you recognize the handwriting.
It's Mr. McIver's.
Okay, so you do recognize it.
Yes, sir.
Okay, and does that letter in 440 fairly and accurately, I guess, depict Mr. McIver's handwriting, which you've seen for the last at least 10 years?
Correct.
Okay. So this time you're on the six, going to tender what's been marked 6 is at 440, you have it?
No objection.
Submitted. Thank you, Judge. Now, in State's Exhibit 440, and I'm going to put it on the screen so you'll be able to see it right in front of you, okay? Can you tell me what the date of that letter, or this letter that the defendant wrote to Miss Diane is?
11/1/05.
Okay, so November 1st, 2005, so right before their wedding in 2005.
Correct.
And if you can for me, if you can see it, will you read to the jury what the first paragraph says?
This letter summarized the advance/deposits you have made to various bank accounts which have not been matched by me.
And for the wedding account, how much had not been matched by Mr. McIver?
$25,000.
And for the construction account that you talked about on direct, how much had not been matched by Mr. McIver?
20.
Okay, and then the last account that had not been matched is the farm account. How much had not been matched by the defendant?
10.
And if you can for me, will you read to the jury what the last paragraph says?
I understand it is my obligation to either repay or match these contributions as soon as possible after the wedding. In the meantime, the deed granting you an individual 1/2 interest in the farm is in your possession.
Now, you talked briefly on cross, about how when you first encountered Mr. McIver, he was, I think you said inconsolable.
Correct.
Okay. Now, when he was crying uncontrollably in front of you, was this also in front of Miss Danny Jo Carter?
I believe Mr. Carter was in the 1502 side, and I don't believe she was present at that time.
during the days you saw him uncontrollably crying, was this also in front of Mr. Corey?
No,
Okay. And when he was uncontrollably crying, was this in front of Mr. Grover when he was there?
no,
Or was it in front of Miss Janie Calhoun?
no,
Okay. So, the only, when he was, I guess, crying uncontrollably, it was only in front of you?
Miss Phyllis may have been in the kitchen.
Okay. And who is Miss Phyllis?
She's the housekeeper.
And these events of when the defendant was having these moments was only in the kitchen in front of you and Miss Phyllis?
Could you repeat that?
Yes, I'm sorry. These events of crying that you described, do they only occur in the kitchen in front of you and Miss Phyllis?
No, I did see him sobbing some in the bedroom.
Okay. And in the bedroom, was it just you and the defendant when this was occurring?
That was pretty much the day that we were I was trying to get the papers signed.
Okay. Now, you told Miss Clark Palmer that you were a registered nurse before you did your duties with Mr. Ted Turner.
Yes,
Okay. And what hospital in Atlanta were you a nurse at?
I trained at Georgia Baptist, which is now Georgia Medical.
I'm sorry, say that again.
Georgia Baptist, which is now Georgia Medical. And then I worked at Piedmont Hospital for private physicians.
Okay. And did you ever work, do you remember telling me that you at one point worked at Grady Hospital?
Yes, I did.
Okay, how long did you work at Grady?
I would just work on weekends with a girlfriend when we wanted extra money to go traveling.
Okay, did you work in the ER at Grady?
No, we usually worked on the surgical floors.
And do you know if Grady is a trauma center?
Yes,
Now, did Mr. McIver or Ms. McIver ever tell you about an incident where Austin burned his finger?
Objection.
Excuse me, I'll rephrase the question, I apologize.
Well, I still object as a speaker.
How does that connect to direct or cross?
We can approach, I can tell you, or I can tell you, on cross-examination, Ms. Clark Palmer talked about lovebirds, and they never argued, and there was a,
Okay.
they were like teenagers.
Keep going.
So,
So overruled.
Okay. May I
If we
stay
need to
standing?
approach, we can
Just in
stay
case
standing.
another objection comes up.
Okay.
and I'll rephrase the question, did Mr. McIver ever tell you about an incident where Austin burned his finger while at the ranch?
no,
Okay. And then Ms. McIver, when she told you it was her new will, did you have any reason not to believe her when she made those statements?
no,
Okay. And I believe Ms. Palmer talked to you about other members of the Corey company or U.S. Enterprises, like Mr. Corey, the owner, and other members of the executive staff. Would they have any reason to be making copies for Ms. McIver?
Objection to that question.
I'll rephrase it, Your Honor.
You need to rephrase it.
I will.
Basically, she ever experienced, but not the way you asked it.
Now, whose duties at U.S. Enterprise it was to make copies for the executive staff?
it varied.
Okay. Well, when you say it varied, who would do those
Well,
duties?
Diane's secretary would probably do some,
Okay.
and, I mean, I have made copies for Mr. Corey, and I've also made copies for Diane in the past.
Okay. Was it, in your experience at working at U.S. Enterprises, was it Mr. Corey's job or was part of his job duties to make copies for Diane?
No,
Was it, in your experience working at U.S. Enterprises, was it the executive staff, whether it be Ms. Brooks, the attorney, Mr. Rickard, or Mr. Grover's job duties to make copies for Mrs. McIver?
not usually, no.
And whose job duties or responsibilities was that?
It was probably her secretary,
Okay, so you
occasionally,
or Mr. Brown?
right.
I don't have any further questions, Judge.
Jurors, questions for Ms. Stiles? We'll pass them usual way. And look who's back. Deputy King, how are you?
Doing good, y'all.
Good to see you.
Listen to hey, everybody.
Stretching. Me too. Another minute. Did Mr. McIver ever tell you what happened in the car on September 25th, 2016?
No,
In answering one of the questions from Ms. Clark Palmer, there was a discussion about maybe there was a pallet on the floor. That was the word that, I don't mean a wooden pallet, but some kind of bed made up by Ms. Anderson in Mr. McIver's bedroom that night or nights she spent the night in there. Did you ever see any evidence of there being bedding on the floor?
no.
Tell the jurors what your feelings are for Mr. McIver now after all this.
He's a very honorable, trustworthy man.
Do you have any follow-up based on any of those questions?
Nothing.
Ms. Clark Palmer?
You shared with us, you just shared with us your feelings towards Mr. McIver today, correct?
Correct.
And you shared with us before your feelings about Diane McIver,
Yes.
correct? Which were all positive?
Yes,
And you still feel that way about Diane McIver today, correct?
yes,
Okay. Love both her and Tex dearly.
very much so.
Thank you, Ms. Stiles, for your time. You're free to go. The state's next witness.
Karen, St. Paul, ADA Michael Sprinkle.
ADA Sprinkle.
Can you raise your right hand for me? Do you swear or affirm that the testimony that you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may have a seat. All right, can you please say your name and spell it for the court?
First name Michael, M-I-C-H-A-E-L. Last name Sprinkle, S-P-R-I-N-K-E-L.
There was someone who was going to ask you questions, but she disappeared.
Yes, Your Honor.
Let me know when you know. All right, we're back on the record. Mr. Showstopper, Mr. Sprinkle. We're ready to go forward.
Good afternoon.
Good afternoon.
If you would introduce yourself to the jurors, tell them your name and where you currently work.
My name is Mike Sprinkle, and I'm a Senior Assistant District Attorney at the Office of the Fulton County District Attorney.
And tell the jurors how long you have been with the Fulton County District Attorney's Office.
Since June of 2011, so about 7 years.
Okay. And where are you currently assigned within the DA's office here?
I'm assigned to the Major Case Division.
And what does it mean in your specific role to be assigned to the Major Case Division?
Well, I'm the head of the unindicted homicide unit. I oversee the pretrial investigation of all unindicted homicides in the county. This involves preparing the cases for presentation to the grand jury and the trial that will likely occur thereafter.
And as part of your role at the DA's office and sort of assisting with investigations and getting a case ready for indictment and eventually trial, tell the jury a little bit about the types of things that you do for the cases that you work on.
Well, it's all sorts of things. Generally, what I do is I receive a case file from any of the various law enforcement agencies across Fulton County. Commonly, this is the Atlanta Police Department, but there's numerous other agencies, the Fulton County Police Department, Sandy Springs Police Department, etc. I take a look at the documents that they provide me, any of the reports that have been drafted by officers, etc., including, in addition to that, audio and video files that consist of witness interviews, crime scene photos, anything, pretty much everything in the case file apart from the, generally speaking, the evidence itself, like anything that was recovered from the crime scene, and that generally stays in the police department until trial, although there are exceptions to that. And after I review the case file, I then identify potential areas that need further investigation. This oftentimes involves cell phone records analysis, forensic analysis of cellular telephones.
Stop for a second.
Once again, I'm sorry, I apologize. Can I come?
Okay.
You want me to make a long speaking objection?
No, if you would like me to say, let's move this along, I'm happy to do that if you have
But the
more.
answer to that is definitely yes, but
Okay.
but I think there's some problem.
Okay.
All right, Mr. Sprinkle, you just told the jury a little bit about some of the things you do related to some of the cases you work on. For this particular case, let's start by telling the jury, did you review and/or order any cell phone records?
Yes, I did. I ordered quite a few cell phone records. Either I ordered them or an investigator from our office obtained a search warrant if need be, and they obtained the records.
And as a result of ordering and eventually receiving these records, did you create any sort of summaries of what appears in those records or demonstratives?
Yes, I did. The records consist of Excel spreadsheets, and what I did is I sorted the data in such a way that it would just include the call details of two particular parties. I believe that's what you're referring to.
Yeah, and I'm going to show you what's already been admitted in State's Exhibit 345, just as an example. Tell the jury to get to the presentable point that we see here on 345. What did you have to do?
I believe with this particular one, I had the cell phone records for both Claude Lee McIver, the defendant, and also Thomas Carter. But I believe to make this exhibit, I just hold up the spreadsheet that is Claude Lee McIver's phone records, and I filtered out all calls except for those by and between Thomas Carter. So that's pretty much all this was. And then I cut and pasted those results onto a different spreadsheet, which I then printed out, which is what you have here. But before I did that, I also changed the time. By default, the time on, these were AT&T cell phone records, the time is in UTC time, which is 4 hours ahead of Eastern Standard Time. Well, 5 hours ahead during the winter, but 4 hours ahead. This would have been October, so it was 4 hours ahead. So I subtracted 4 hours, and the accurate time is displayed on the records that are on the state's exhibit that you have in front of you.
All right, and did you make that adjustment that you just told the jury about on all of the summaries that you reviewed as related to this case?
Yes, I did.
Okay. Did you also order and eventually obtain any cell phone records for landlines or home phones related to this case?
I did. The defendant had a landline phone at a condo that serviced a condominium on Kingsborough Road, and he also had a landline phone that serviced a property in Putnam County at Pea Ridge Road.
And did you create a disk with your initials on it related to those specific records?
The landline record?
Yes.
Yes.
All right, and Your Honor, at this time, the state's going to tender by way of certification, State's Exhibit 412. Yes.
Is it landline for both addresses you mentioned? Okay. It's admitted.
Thank you.
Oh, sorry, I must have misunderstood what I heard over here.
There's a difference between that
Okay.
and that.
So
I'm contemplating. Can you give me a second?
you sure can have a second.
If I may speak more.
Counsel?
No objection. Thank you.
Okay, 412, admitted.
Tell the jury, did you do anything related to looking at a particular device or hard drive for any emails?
Well, yes, I did.
Okay, what did you do?
The GBI earlier in the investigation, through an analyst with that agency named Lisa Arnold, was given a hard drive that was recovered from the work desktop computer of Diane McIver, the victim in this case. The GBI used forensic extraction software to take an image of that hard drive. Briefly stated, an image is basically an exact copy of the hard drive in digital form. I, in turn, received a copy of that image, that being an exact digital replica of the hard drive in Diane McIver's work computer, and I went into the directories on the hard drive, and I knew where to look, specifically the Outlook, the Microsoft Outlook directory, or a directory associated with Microsoft Outlook, and I found what's called an OST file. It was a very large file. It was well over 14 gigabytes, and I knew that file to essentially be like a digital cabinet. It contained all of Diane McIver's emails. So after I found that file, I used software to extract the emails, or to rather render the emails such that they would be understood by a human being. In other words, I used a program to unload the emails from that OST file, and then I reviewed them accordingly.
And the software and the way that you were able to get those emails off of the hard drive and the image that GBI gave to you, anything about any of the steps that you took or just told the jury about that allowed you to change or alter the content of those emails in any way?
No.
Have you been able to, in fact, print and pull specific emails related to this case as a result of the images and the software you used in this case?
Yes, I was able to do that.
Okay. Your Honor, at this time, since we're doing a quick sidebar over here, I would ask that the court publish the stipulation I just provided you.
Okay. Ladies and gentlemen, the state and the defendant stipulate that the hard drive that you just heard about, belonging to Diane McIver and collected from her office at U.S. Enterprises, was sent to the Georgia Bureau of Investigation for digital forensic analysis. If called to testify, Lisa Arnold, who is a cybercrime analyst with the Georgia Bureau of Investigation, would state that she executed a procedure that allowed her to create a digital copy of the hard drive from Diane McIver's computer. Ms. Arnold's digital copy included all email correspondence contained on that computer. And during her analysis, Ms. Arnold did not change, alter, delete, or add any content to the hard drive. So this is a stipulation entered into between the two sides in lieu of having Ms. Arnold come in here and introduce herself to you all and answer a whole bunch of questions. The stipulation is signed and dated March 14th, 2018 by Ms. Convery on behalf of the state, Mr. Harvey on behalf of Mr. McIver, and Mr. McIver has initialed it as well.
Mr. Sprinkle, I'm going to show you what's marked as State's Exhibit 147. You know if you recognize that and its content.
While you're looking at that, Mr. Sprinkle, I'm going to make that stipulation Court's Exhibit 6 so that the document is in the record as well. And we'll take it.
Yes, this appears to be a binder that in which I placed a selection of the emails that I reviewed. I printed these emails out and I placed them in this binder. There looks like there's been some tabs added that correspond to a table of contents at the front. But apart from that, these appear to be, as I stated previously, emails that I obtained from Diane McIver's computer.
And the emails that are inside State's Exhibit 147, are they a true and correct copy of the emails that you personally were able to download and then physically print off?
Yes, I actually printed off all of these emails that are in this binder, and I found them myself on Ms. McIver's hard drive.
Okay. And what you printed off, did you change, alter, or delete in any way from the image that you received from the GBI?
I did not.
Your Honor, State's going to tender 147 into evidence.
Mr. Harvey?
Yes, I have somewhat of a split decision.
Okay.
I don't object on authenticity, to the authenticity of emails. I'd like to reserve the objections to the particular emails admissibility, so as a bulk exhibit. That's my, I guess, split decision.
Okay, what I'm going to do is handle this as 147 is admitted in mass. Whether any of its contents sees the light of day would depend on a particularized consideration of, and the state's going to need to come up with an effective and efficient nomenclature system, 147A, or however you want to do it. But we will need to handle the contents item by item. I do understand that you and Mr. Samuel have been working closely, and some of that may flow smoothly, but I appreciate Mr. Harvey's acknowledgement that he is not objecting that these are what Mr. Sprinkle said they are. That doesn't necessarily mean we can start publishing them.
Sure, and we're going to work through that individually with witnesses as we go.
Okay. Sure. 147 is in under those guidelines.
All right. Mr. Sprinkle, in addition to going through some of these emails and creating what you have there in front of you, did you have an opportunity to review a particular set of videos related to this case as well?
Well, I reviewed a number of videos related to this case.
Specifically the Midtown Blue surveillance cameras.
Yes, particularly the one at, well, I've watched them both, but the one at 10th Street in particular that depicted the front of the vehicle.
Yes. Looking at that particular surveillance, were you able to actually slow down the video using any sort of software to go frame by frame?
Yeah, well, the videos, they can be played with some proprietary piece of software, as is the nature of most surveillance videos. But in addition, I was able to play the video using a very commonly utilized consumer-grade video player named VLC Media Player. And the reason why I did that is VLC has a lot of functionality to include the ability to zoom in on the video. And that's what I did. I used that particular media player to zoom in on that surveillance video.
And as you're taking a look at this surveillance video, did you make an attempt to zoom in to try to get a better look at that particular vehicle we've been talking about?
Yes, the Ford Expedition, yes.
Okay. I'm going to show you what's been marked as 436, 37, 38, and 39. Let me know if you recognize those.
I do recognize these.
And are they a fair and accurate depiction of sort of screen grabs or screenshots from the process that you just told the jury about?
Yeah, in fact, I printed these out myself.
Okay, no changes to the images that you have there in front of you?
No changes at all.
All right, State's going to tell me what has been previously marked as 436 through 439.
Okay. Mr. Harvey, other than what we discussed at the sidebar, any objections to 436 through 439? Okay, they're admitted.
And Mr. Sprinkle, when you did that and you did this Zoom attempt, were you able to get any quality images as a result of what you attempted to do with the software?
Well, on the monitor in front of me, I believe that's 436, that's the image. I didn't think that it was all that useful. I couldn't identify the people in the vehicle. But that was about as clear an image as I was able to produce with this process. That's 437 it appears to be, and again, that is an image depicting the front of the vehicle, and as you can see, I really focused in on the windshield of the vehicle.
All right, I'm going to show you 439. I'm going to zoom it out a little bit. Tell the jurors why we see that sort of little in picture right there on the top of 439.
Well, that's, you're talking about this part right here?
Yes.
That is the a thumbnail displayed within the video player window that shows the full video. And this little white box right here, that is the portion of the video that has been magnified through the zooming process.
Once you looked at this video, went through the initial file, but most importantly, the things we've talked about before the jury today, did that complete your involvement in the investigation part of this particular case?
Well, there are a few odds and ends that I did here and there, but those are the main points, yes.
And when did our office, the Fulton County DA's office, actually receive this case from the Atlanta Police Department?
It would have been, I believe, on December 22nd or 23rd of 2016.
I have no other questions, Your Honor.
Mr. Harvey, any questions for Mr. Sprinkle? Okay. Any questions from the jurors for Mr. Sprinkle? Nope. Thank you, sir.
Thank you.
get partway through another witness before we break? Is that okay with everyone? Okay. Maybe. Okay, you go while we get the next witness. Next witness, please.
Yes, sir, Your Honor. State call Harold Hudson.
Raise your right hand. Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, sir, if you will. Have a seat. Get as close to the mic as you can during the testimony.
Okay.
For the purposes of the court's record, please state and spell your name.
Harold Hudson, Haroldhudson.
Good afternoon, Mr. Hudson.
Good afternoon, Mr. Rucker.
Could you please start out by introducing yourself to the jurors, turn and face them, and tell them your name and tell them how you are employed.
My name is Harold Hudson, and I am a lawyer. I own a law firm here in town.
Okay. And could you share the name of your firm?
The Hudson Law Firm, LLC.
Okay. And can you tell the jurors you are licensed to practice law in the state of Georgia?
I am.
And can you share with them what types of law do you focus on primarily?
Primarily at this point, I focus on residential real estate closings, purchases, buying and selling of houses, those closings, and closing of refinance transactions. I also, to a lesser degree now, prepare people's last wills and testaments, handle probate, and do some tax-free exchange work.
Okay.
I'm sorry, last thing you said?
Tax-free exchange work.
And I think just through our email correspondence, this is a busy time of year for you.
It is.
Okay.
Fortunately.
Okay. Good. I will try to be kind of brief with you, okay? Because I appreciate you being here. Now, can you tell the jurors, did you become acquainted with the defendant in this case, Claude Lee McIver?
I did.
And can you share with them a time frame? When would that have occurred? The first time?
I want to say that it was in 2009.
Okay. And generally speaking, how did you become acquainted with him?
I believe that I became acquainted with him through, I was trying to think of how I came to know, somebody referred Tex to me, Mr. McIver, for me to do some work for him.
Okay. And out of that meeting or that interaction with Mr. McIver, did you come to meet Diane McIver?
I did.
And can you tell the jury, was there a period in time when there was a request from the McIvers to assist them with a particular legal matter?
Well, it wasn't a particular legal matter. There were a number of different matters, but initially I started doing some work. I think the Tex wanted me to do, to look at doing their estate planning. They had a farm that they use for business entertaining and personal entertaining, and we were going to look at how to structure their affairs in the most efficient income tax manner. Also, there was a concern for asset protection and how to structure their holdings to make sure they minimize their liability exposure. And included in that estate planning also was looking at their wills and how all that fit together. So it was a multi-level and process.
Okay.
I'm sorry, Mr. River. Just for the record, I'm renewing my objection to this witness's testimony, which is something I need to talk about.
Okay, it's renewed.
Now, with respect to the wills, can you tell the jury what was your role with respect to that?
So my role with respect to that was looking at their current wills and then talking to them about what changes they wanted to make to those wills in light of the other planning that we were looking to do. And Diane had a lawyer by the name of Ken Rickard, who was an in-house lawyer with her business firm, and he was also involved initially as well.
Okay. And can you tell the jurors, in that 2009 calendar year, were you able to complete wills, new wills for Diane and Claude McIver?
My recollection is no.
How about 2010?
My recollection is no. We never completed new wills for Tex and Diane McIver.
Ever?
That's my understanding. That's my recollection.
Okay. And can you explain to the jurors why not?
Well, sometimes doing people's wills is like trying to sell them life insurance. It's really not up on the fun list of things to do. And I find in almost 30 years of practice in law, I find it can sometimes be difficult to get people to come in and go over these issues. I was telling somebody the other day, most people, when they describe, when you start talking about their wills, they say, now, if I die, and I'm like, well, if you die, you're going to die. It's just a matter if you come to grips with it. So I find that for some people, it's not a fun task to do. Tex and Diane appear to be very, very, very busy people, flying all over the place, having business meetings, and so getting them to come back and go over these issues was exceedingly difficult.
Okay. Fair to say there were many appointments made to deal with these issues?
There were a number of appointments made. There were a number of appointments that were canceled, some of which were at, the morning of or something like that.
And your primary contact, maybe not all the time, but the primary contact person who kind of dealt with you with the scheduling and the appointments and any cancellations, which one of the McIvers would that have been?
That was Mr. McIver.
Mr. McIver?
Yes.
Now, there were occasions, though, there was at least, well, strike that. Let me ask you another question. How many times did you actually meet with them to go over their wills?
Once or twice, I believe.
Okay. And can you tell the jury, were there email exchanges between yourself, Mr. McIver, and Mrs. McIver, wherein some of the issues that they were concerned about with respect to their wills would be discussed in the email?
Yes.
Now, can you tell the jurors, based on the meetings and the emails between the McIvers and yourself, was there ever a disagreement raised with respect to how each one of them wanted to have their wills constructed?
Yeah, there was as I recall, the issue was concerned the way that the property, their ranch or farm property was held, so yes, there was a disagreement.
Okay, so now what do you mean about the way the property was held?
Well, I have not gone back and exhaustively looked at this, but my recollection, and you have all the emails, but my recollection was that their farm was held as joint tenants of rights of survivorship, and what that means is that if two people hold property as joint tenants of rights of survivorship, and one of them dies, then what that means is that the survivor is automatically vested 100% with the entire ownership. And the deceased person, their estate has 0 in it. So there was an issue. It's my recollection, that's when they came to be my clients, that's the way the farm was held. And then my recollection again is that we had wanted to, and it wasn't just me that was doing this planning, there were other accountants, and like I said, the other lawyer was involved. We wanted to, my recollection is that we wanted to put the property, the farm, into an LLC, and that was going to change the way that this joint tenants rights to survivorship property was going to work. And so there was a disagreement on how to do that.
The ranch was held joint tenancy right of survivorship.
That's my recollection. I haven't gone back and looked at the deed. Like I said, this is 2009, 2010, but that's my recollection.
Okay. And with the joint tenancy ownership relationship to the ranch with the right of survivorship, is it fair to say that one person has about 50% and the other person has 50%?
Sure.
Okay. And so if one person dies, the other person has what ownership interest?
100%. On the death of one of them, if this person were to die, at the moment of their death, theirs goes to 0 and that one goes to 100.
Okay. And can you tell the jurors, when you were having this meeting and this email exchange with the McIvers, did the issue of a young man by the name of Austin arise?
I can't recall if he was in the subject of the joint tenants rights of survivor in the email exchange on that, but certainly he was to be a beneficiary under their estate, and they wanted some mechanism to provide for that, and that's about as good as I can get without looking at the emails.
Okay. Okay. Do you recall testifying under oath before the Fulton County Grand Jury on April the 11th of 2017?
I sure did.
Okay. Do you think if I showed you a copy of the transcript from your testimony, that might help to refresh your recollection on that point?
Sure.
Okay. Councilman, page 6. Yes, ma'am. Line 16 is the question. Okay. So let's just start here. Flips over. Flip page. If you just read silence yourself.
Okay.
Okay. Now, after having read through those, that transcript, is your memory refreshed about that question?
Ask me the question again, please.
Sure. Austin. How did Austin factor into the discussion between the McIvers and yourself about constructing their wills, their new wills?
Okay, I thought your question was about how it related to the joint tenancy property,
Okay. No,
and how that, because...
I'm sorry, go ahead, I didn't mean to cut you off.
Because what I just read here was that, it wasn't an issue. The issue wasn't, hey, you can have everything. I mean, they had that set up before they came to me. I think the issue was, as I said here, what's happened after they're both deceased? Where does that ranch go?
Right. And what did you understand was Diane's wishes with respect to where the ranch went if she was deceased?
I can't recall where she wanted to go. I think that she wanted it to go to, and I have in emails on this stuff, but I think that she wanted it to go to Austin, her godchild or grandchild or something like that. It wasn't her grandchild.
Right.
And she did not want it to go to.
I'm sorry, may I just object to where she didn't want it to go as being non-responsive, not relevant? The question was vis-a-vis Austin, which I think he answered. She wanted it to go to Austin.
Okay. I think the court knows what the next question is.
Yeah, I mean, we're gonna bump into it, it sounds like one way or the other, but your answer was stopped, so we'll keep going with questions.
Yeah. So to make sure we're right before you were cut off, you knew that Diane McIver wanted the ranch to go to Austin upon her death.
I believe so.
And can you tell the jurors what was Mr. McIver's desire about his interest in the ranch upon his death?
Well, I can't really recall exactly where he wanted it to go. I think that he was not, he'd been married before.
Right.
He had 3 adult children, is my recollection, from his first marriage. And I don't think that he was particularly close to 2 of them. So I don't really, without looking at my notes, I couldn't tell you exactly where he wanted it to go.
Okay. But is your recollection that they could not come to an agreement?
That's my recollection.
Okay. I'm going to show you an email. Counseling was dated 1/26. Well, the beginning of the chain is 1/25/2011 at 9:01 a.m. And that chain concluded at 1/26/2011 at 2:15 p.m. And for understanding what the court has indicated about how we can track these, I will state for the record that in the table of contents, this email is listed as email number 10. However, for purposes of the record, I'd like to submark it as state 147, and I'll take some direction from Madam Court Reporter. Would it be easy to track letters or numbers?
I think to keep it consistent, I don't mean to speak for the court reporter, but if your table of contents has the number, then this should be 147-10.
Okay.
Is there any way we could go ahead and take our afternoon break now? I have these emails, not in this format and not in the order that I could pull them up quickly. If we could do that right now, I'm sure I could get to where I could track them.
That'll work. Let's do that. Let's try to be back around 4:05. Friends and jurors, don't talk about the case during your break. We'll get Mr. Hudson back in here, and we'll have streamlined a little bit more of this process with the numbering. Thank you.
All rise for the jury.
Cases, they're not hearsay because they maybe from Mr. McIver. And it's kind of a back and forth. So overall, I object to getting into the proposed changes from 2011 because it's so remote in time. And then the later emails, I think there's only one. They're all from either 2009 or 2011. Then there's one other email from 2014 to Mr. Hudson, between Tex and Diane and Mr. Hudson about going in to see him in August. They don't agree to go see him, but there's just some conversation about should we go finalize our wills with him. But there's no agreement that, yes, we're going.
Is there a disagreement or just doesn't quite come to fruition?
Doesn't come to fruition, like it's, to paraphrase, Mr. Hudson says, great, what time? Tex says 9, if that works for Diane, and Diane responds back, can't do 9.
Okay. But it's evidence that they were continuing their discussion.
So the other part that, it's the continuing the discussions part that is, in my view, there's no resolution. Mr. Hudson lays out in 2011, here's what I thought I heard you both say you wanted to do. There are some emails where, Ms. McIver says, I think there's one email where she says, here's something I have a problem with. But there's never an email from Ms. McIver where she says, here's how I want my will to be. It's just, here are the things I have a problem with. There's no proposed changes from her side about, here's how we ought to resolve the disagreement. There's no emails from Mr. McIver saying, I disagree with what you want to do. It's just her saying, basically, I don't like what Mr. Hudson laid out. So there's no resolution about what her proposed changes are. So because of the remoteness in time and because we don't have any concrete proposed changes that Ms. McIver wanted to do, that's why I'm asking the court to keep it out on relevance grounds. It's complicated too, which I know isn't necessarily an objection, but I think it does waste time explaining, what does it mean when it's joint tenants' rights of survivorship, and now they're trying to move it into an LLC and interest to somebody else. I mean, even myself going through it, I always have to kind of write it out and say it 2 or 3 times before I think I'm speaking English.
Sure.
So that's why I'm asking the court to keep it out.
Are there hearsay concerns that we ought to work through as well? Even if relevant, if not too remote, if not too complicated, we've got an issue with X, or is it the kind of thing that we often see with modern day communications where there's enough attributable to your client that we really are we need to get the whole conversation so that your client's statements aren't taken out of context? I'm not asking you to come up with something. I just want to avoid, if I say, actually, I'm going to let the state go forward on this topic, then we need to work through hearsay later.
There is some hearsay from Diane McIver that is not necessary to explain a statement from her husband. And for example, I'm looking at one where she's the last one to respond. We don't need her response to explain anything that he said previously.
And these would be emails that were not part of the 807 notice?
I mean, one of them was, I'm looking back through the one, there's one from August 4th, 2011, that was in the 807 notice. There was another one that was in the 807 notice, but I don't think it's in the notebooks. I'm not sure about that. Right, but the other ones were not in the 807 notice.
So what are you proposing? Let's just use the example you gave where the last communication and change from Ms. McIver, that should go up on the screen, or is it something you've looked at and you say, yes, it's hearsay, but frankly, I don't care, and I don't, if the rest of that chain is coming in, it doesn't trouble me if that comes in, or should. I direct the state not to publish that part of it, and if any of this went back to the jury, part of it would have to be redacted.
Right, so looking at the email, well, okay, so let me start with one from January 26, 2011. What Tex says is he forwards Diane an email about what time to meet with Harold Hudson. And then there's back and forth about whether or not they're going to go. So, I mean, I object to that one coming in. Wasn't attached to the 807 notice.
Does it have a number?
It's part of the,
It's going to be 14710.
okay.
The one from January 2011? Okay.
I mean, this one said, so,
Pretty big. We'll take a look at it.
yeah.
Well, if it wasn't part of the 807, then...
We'll check it right now.
Okay. I remember 807 was like this. It was 80-something pages.
It was 80 pages?
67.
67,
Well,
okay.
I'm not, maybe that's not a problem, I'm not looking at the right one.
69. Not including the plea, yes.
So then I apologize, I was looking at the wrong. So that one is not in the 807.
So I'm wondering if we need to have Mr. Hudson come back tomorrow because time's a wasting, and this is the kind of thing that really the state ought to flag for you the ones they wanted to use a little further in advance. And if one of them isn't in there, but they think it is, it doesn't seem like the time to work through all that.
And I apologize, I just thought that we had worked out the admissibility of the email subject to land foundation.
This one's in there. Yeah, I'm sorry.
Okay, I thought so too. I thought, I'm not holding anyone to it, but I had thought that there was a conversation, maybe putting the wrong names on, between Ms. Connery and Mr. Samuel, and it was, actually the emails they're not going to be a big issue. That doesn't mean it can't be, and I'm happy to handle it in whatever way we want, but not while the jury is sitting back there ready to come in. So if we're now dealing with, we don't even know if it was in the 807 notice, it seems like we ought to do something else while we work through that.
Well, I will apologize, it's my fault, I was looking at the wrong pleadings. These two that I'm looking at now are in there.
Okay?
So I'll maintain my objections. I don't remember that the court ruled all these are coming in, and if I misheard that, then I apologize.
I didn't.
So I maintain my objection based on the relevance grounds, given that they're so long ago.
Okay, that's one that's what we talked about, and we said we'll work through it. I continue to hold that in light of what the jury has heard, the testimony, the exhibits, etc., even though this is a few years before the incident that brings us all together, it is not so remote that its probative value is, I think it is relevant, and I think that it is not without relevance. It is less relevant because it is more remote, but any prejudicial effect doesn't substantially outweigh that probative value. So that one, you preserved your objection, and I continue to deny the motion and eliminate. What we had, I believe, had kicked the can down the road on was, well, we got to see with the individual emails, here say this, here say that. So that's what I thought Ms. Convery and Mr. Samuel had been talking about. You didn't ever waive anything on any front, but I had ruled, and I'm maintaining that ruling on relevance. So I guess my question then to the defense is, assuming that I maintain my position as to relevance, is there anything beyond that that you want to get on the record?
No.
Okay. Then anything else you'd like to talk about, Ms. Clark-Palmer, before we bring the jurors back? Okay, and I want to be clear, if Mr. Rucker is sharing one of these exhibits with Mr. Hudson and a new idea pops into your head about, wait a minute, there is an issue with it, you haven't waived that ability to say, here's a new theory. And you've preserved the remote in time, so not relevant. It's preserved, just I'm denying it on that. Okay? Let's get Mr. Hudson back in here, please. Let's get the jurors back in here.
You're ready to go, John.
Great, let's bring them in.
All rise for the jury. Jury is all present and accounted for, Your Honor.
Thank you, Deputy Kane. You all can be seated. Sorry for the delay, folks. There are complicated legal arguments intertwining these emails that are about complicated legal subjects, and my small legal mind needed more time with the lawyers to try to figure out what was okay for Mr. Rucker to ask Mr. Hudson about. I don't claim I'll necessarily understand any of Mr. Hudson's answers, but at least we've charted, I think, a clearer course as to where Mr. Rucker can and can't go with the kinds of things he wants to explore. So that just took a minute. Mr. Rucker, back to you.
Yes, sir. Okay. For the record, I'd like to show Mr. Hudson, this is State's Exhibit 147-10. And it's an email chain, and you know they go from back to top. So if you look at the back page first, it'll give you some context about what time and date the initial email was generated. You see that?
Yes, I do. Sorry. Yes, I do.
Okay, can you tell the jury what is the date and the time of the originating email? And if you could help orient them, and actually, let me just see it back. You got this computer screen right here. I think it might be easier. Okay. So the email is from who?
It's from me,
To who?
Tex McIver,
And who is copied on the email?
Ken Rickard,
Okay. And what's the date of the email that it was sent?
January 25, 2011 at 9:01 a.m.
Okay. Let me scroll down a little so you can read it for the jurors. Can you see it? Is that too small?
I can see it.
Okay, if you would please just read that, the content of the email for the jurors.
Tex, I have you and Diane down for Friday morning at my office at 9 a.m. As you know, we need to either have Diane's attorney, Ken Rickard, present, or on a speaker
Slow
phone.
down just a second and just speak up loud so everybody on both sides of the room can hear you. Okay?
Tex, I have you and Diane down for Friday morning at my office at 9 a.m. As you know, we either need to have Diane's attorney, Ken Rickard, present, or on the speakerphone, or I must have his permission to meet with Diane without him. Thanks. See you Friday, ! Harold.
Okay. Can you explain to the jurors why did you say you needed to have Mr. Rickard present, or at least present through the speakerphone, before you could meet with Diane alone?
Well, Ken had been her lawyer, and so when I am aware that somebody has a lawyer, that I'm supposed to go through and notify that lawyer of what we're doing. A lawyer like myself can and normally does prepare a will for a husband and wife without one of those parties getting another lawyer. But she already had Ken, who had been, before this 2011, he had sort of been involved in all the other planning that we were doing besides the will, and he had been looking over a number of other documents, and so I just continued that.
Okay. And so you had your first meeting with the McIvers in 2009. This email is 2011, and by the time we have this email, do we have an agreement with respect to wills for Diane and Claude McIver?
Well, let me just say, I'm not, you just said that I had my first meeting with the McIvers in 2009. I started doing work for them, I know, in 2009. I'm not sure I met with both of them in 2009. I may have, you may be correct,
Okay.
but I can't recall that as I'm sitting here.
Okay, okay.
So yeah, we started working, definitely started working in 2009, and then here we are, and I forget when, I want to say it was like, I don't know when in 2009, but so, you know, here we are at least a year and a half, maybe 2 years later.
I'm going to show you an exhibit. It's 147-1. This is the one. Very good. Take a look at this exhibit. It's also an email. And see whether or not that exhibit refreshes your recollection about when you may have started an email exchange or having meetings with the McIvers regarding their estate planning.
So the first email here in the chain is from me, and it's dated September 1, 2009, and it is to Tex McIver and to a CPA by the name of Twiggs Kelly. And that starts off saying, to recap our meeting this past Friday, Twiggs, the accountant, is going to telephone Tex McIver's accountants concerning blah, 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 blah.
Just so we have this work smoothly going forward, I think poor Mr. Hudson's been asked to use these things in two different ways, but you asked him if it refreshed his recollection. So we need you to stay on that and see what he has to say about that.
Okay.
So I don't, what your question was, does this refresh my recollection of my first meeting with Tex and Diane?
Okay.
It does that with respect to Tex, but I'm not clear from this email whether or not Diane was at that meeting or not.
Okay, fair enough. I'll come back to that while they're looking at that exhibit. We're still on states 14710. And after you have scheduled a meeting at your office on Friday morning at 9, there's an email from whom?
Tex McIver
To
Diane McIver,
what date?
January 26, 2011.
And the meeting had been rescheduled, is that right?
That's what he says here, please see below, meeting has been rescheduled to 10.
Okay. And then there's a response from Ms. McIver. From who?
Like you just said, Diane McIver.
To whom?
Tex McIver.
Okay. And what date?
January 26, 2011.
And what did she say?
I am not wasting Ken's time until you and I agree on what we are going to do. ...
There's a response from Mr. McIver.
Mr. McIver, this is an email from Mr. McIver to Diane McIver on January 26, a couple minutes after Diane sent the email, and it says, upon what do we not, NOT in caps, agree?
And about 5 minutes later, what is the response from Diane McIver back to Tex McIver?
that I am not going to leave my half of the ranch to your estate. You are throwing money away on Friday morning, ...
There's one rogue fly flying around here. I apologize, but I've never seen a fly before. It was here before, Mr. Hudson. And I don't know what the deal is, so I apologize for that. It looks like it weighs about 5 pounds. But we'll work on it. Deputy Kane, if you want to get out your fly suppression unit.
Okay. Let me show you an exhibit. I've shown it to the defense. It's marked, Your Honor, as State's Exhibit number 442. Counsel, any objection?
A relevance objection, it's a document from 2009.
Yes.
Okay, can I see?
Yes, absolutely, Judge.
Is it what? Okay, he can finish reading it.
Oh, yeah.
Take a look at it.
Okay?
Can I see it personally? Thank you. I'll allow it. The remoteness in time objection is noted.
And also hearsay, I should have added that, hearsay objection. I know it's by this witness, but it still contains hearsay in it, and it also contains, it contains sort of recaps of what would have been told to him by other people.
Okay. Mr. Rucker, what's the hearsay, response?
Well, it's not being offered for the truth of the matter, Your Honor. It's really being offered to show when this witness would have engaged both Diane McIver and Claude McIver, which is the question raised about it.
Okay, and that's the sole purpose for which you use that?
That's correct.
Okay, it's not something that would go out with the jury anyway. If you want to see if it refreshes his recollection, that might be the best way to use it.
I can do it that way.
Let's do it that way.
Having had a time to look at State's Exhibit 442, Mr. Hudson, can you tell the jurors, does that document refresh your recollection about when you would have engaged both Diane McIver and Claude McIver with respect to their estate planning?
In 2009,
What date?
December 30th, 2009.
This is State's Exhibit 14714, and this email is from who?
Me,
To who?
Tex McIver,
What date?
May 5th, 2011.
So if this email that we just looked at was January 26, 2011, we are a few months after that, correct?
Correct.
Okay. There was a response email from whom?
Tex McIver,
To whom?
Diane McIver.
Same date? May
Yes,
5th?
yes,
Okay. And it says, please review, correct?
correct.
Referring to the email that you sent to Mr. McIver.
That would be my supposition.
Okay. And just so nobody's wondering, you are talking to them about the ownership rights of the farm.
Correct.
And you tell them there, you tell Mr. McIver, he and Diane own the farm as joint tenants with rights of survivorship. Correct?
Right.
Is it going to stay that way? Correct?
Correct.
And then you talk about some other alternatives or some other things with respect to what they could do.
Correct.
Okay. And so at the top of the chain, Ms. McIver responds back to the defendant. Right?
Correct.
Same day?
Next day.
Next day.
Correct. May 6th. May 5th, May 6th.
That's right, you're right. And also kind of keeping your voice up and speaking very slowly, could you read for the jury what Ms. McIver said in response to the email from Mr. McIver?
Text, I just read this email, ... Why are you going over there and wasting money until you and I decide what we're going to do upon our death, ... For you to die before me and allow me to live there until I die and then turn it over to your estate is not an option for me. I keep it up for Robbie to get and sell when I die. ...
So at least in 2011, May, what did you understand was the issue regarding completing the wills for Diane McIver and the defendant?
How the property was going to pass after they were both deceased.
And what did you understand Mr. McIver wanted to do?
I don't recollect that. I think you asked me that earlier, and I don't recollect that. I'm sure I've got some emails that bear it out, but from this email, I'm guessing that...
Well, don't get it. I don't want you to guess.
It's
okay. You don't recall?
I don't recall who Robbie is.
You don't know who Robbie is?
I can't recall who Robbie is in that email.
Okay. And did you have a clear understanding of what Ms. McIver's wishes were?
As I sit here right now, I don't, but I have got a goo of emails that pretty much lay it out, I believe.
Is that a technical term?
Goo is actually a legal real estate term.
It is.
It's also, if you squinch something, I use that a lot. That's also a legal term. Squinching your signature in there.
Squinching signature. Okay, I gotta remember that.
That's Latin, actually.
Take a look at this transcript from a hearing that you previously attended.
Okay.
I'm going to refer you to page 83. There's a little yellow sticky note there.
Okay. I'm here.
And go down to line 21, which is where the answer begins, or actually the question. And then if you read over to the next page, line 3, then I'll ask you some questions.
You may start reading on line 21?
No, I'm sorry. Page 83.
I'm there.
Line 21. Yes, sir.
You won't? Okay, so I'm going to start reading.
Read it silently to yourself.
Okay. Okay, where do you want me to stop reading?
Just flip over the next page to line 3.
Okay, I got it.
Got it? Okay. So during the hearing, can you tell the jurors, when you were asked the question, whether or not you knew that Diane's objection was she didn't want Texas children to be able to take an interest in the ranch, what did you say?
I said that's correct.
And then when you were asked the question and they disagreed or talked about that in your presence, what was your answer?
Yes.
And then I'd like to show you this email just to see if you remember the answer to this question. When do you think the last year would have been where a meeting was attempted to be had with the McIvers to discuss resolving some of these issues and creating a will for the both of them? Last year.
Okay, I think it was 2011.
Okay. Let me show you 147:18.
I got it.
Email discuss trying to get a meeting together with the McIvers to talk about their will.
Oh, yes.
And can you tell the jury what is the year, actually the date of that email?
It is Tuesday, August 12th, 2014.
So as of 2014, we're still trying to work on these wills.
Yes. Or at least get a meeting.
Now, did you ever come to know or meet a woman by the name of Rachel Stiles?
I met her outside earlier today.
Back in 2014 or 2015, did you know her at that time?
I don't believe so.
Now, can you share for the jurors, when you were called before the grand jury, when you asked the question of whether or not you had in your possession a copy of a will that had been executed by Diane McIver?
Yes.
And can you tell the jury at that time, what was your response to that question?
That I did not.
Now, do you recall telling the grand jurors that you actually did not know? You recall saying that?
I don't recall that.
Do you still have the copy of the grand jury subpoena right in front of you?
I do.
All right. Would you please turn to page 18? And I can direct you. You can start at about line 16. You can go to the end of the page. And the first 2 lines of the next page.
Okay.
Okay? Now, that you've had a chance to review the transcript from the grand jury, can you tell this jury here today, what was your answer with respect to whether you thought that you had a copy of Diane McIver's will?
That, in fact, I did believe that I had a copy of her will.
That's what you said to the grand jurors.
Yes.
And in fact, on page 19, can you tell the jury, did you actually tell the grand jurors, I could have sworn to you that I had those documents?
That's correct.
Because prior to your attendance to the grand jury, my investigator gave you a subpoena.
Right.
For documents.
Correct.
And for your attendance at the grand jury.
Correct.
And when you arrived at the grand jury that first time, did you bring the documents with you?
I can't recall if I did.
Okay. Well, let me ask you this. Can you tell the jury what happened the next day after you testified at the grand jury?
So I went back, this is my recollection, and I sent you an email about this, but my recollection is that I went back and I have a couple different files. I have an electronic file, which I keep PDFs and Word documents in, and I have a paper file that we keep paper documents in. And then I also have a copy of all the emails that I have sent since 2003. So I went back and started looking through the emails back and forth, and in fact I found copies in the email exchanges of copies of Tex and Diane's wills that they had done in 2006.
But prior to your attendance to the grand jury, you did not bring any of those emails or wills with you?
Well, I didn't bring the wills. I guess I didn't bring the wills. I can't recall exactly what the sequence of it was, but I would have looked in my electronic file, and I don't believe that they were in there. And I do not believe that they were in the paper file either.
Okay.
But they were attached to the emails.
Okay. So after you testified at the grand jury that you thought you had the documents, you didn't know, you couldn't recall, the next day, did I have some investigators come to your law office?
You did.
And what was the purpose that they were there?
They were looking for documents.
And we have search warrants?
Emails. Yes.
And can you tell the jury, when we arrived that morning, had you put some documents together?
Yes. As I, before, that night, or early morning hours of having gone to the grand jury that first day, I went back and started looking and found those attachments and found, and provided a bunch of emails and those documents.
Right. And how did you have those documents packaged for us when we arrived?
In a brown legal folder.
Okay. Now, can you tell the jury, before we actually arrived at your law office that next day, it was early in the morning?
I don't remember what time it was.
Okay.
10, 11 o'clock, something like that.
Okay. By the time we got there in the morning, had you also prepared another copy of the documents in an accordion folder?
I had.
And can you tell the jury who was that second copy of documents prepared for?
For for Mr. McIver's attorneys.
And what was his attorney name at that time?
I believe his name is Stephen Maples.
And how did Mr. Maples know to come pick up documents regarding Mrs. McIver's will and the emails from the time that you had left the grand jury that day before?
Because before I went and spoke to the grand jury, I had a conversation with Mr. Maples and told him that I had been subpoenaed and asked to go down there. And as he was Tex McIver's attorney at that point, I wanted to get his permission to make sure that I wasn't violating some attorney-client privilege by going down there and testifying. And he said, no, go ahead, and if you'll just give me copies of whatever you give them.
Okay. And so you did the next morning, correct?
I did.
Okay. And when we got to your office, was your computer actually seized?
Well, in the sense, was it taken physically out of my office? No.
No. But what was done?
You had people there that downloaded, like my understanding, they were downloading all the information from my computers.
From the GBI?
I believe so. I can't recall.
Okay. And while we were there at your office, can you tell the juror, did we become aware that there was a second location where you also maintained client files?
That's correct.
And where is that second location?
At my house.
And so when we left, got finished at your office, did we go to your house?
We did.
And it was with your consent?
It was with my consent.
And you took us where in your house? Where you keep your...
Down to an unfinished portion of my basement.
Okay. And when we got there, can you tell the jury, did we find another McIver file? Client file?
There was a paper, brown paper folder. I think you have it.
Yeah.
Yeah.
And is there a particular individualized client number assigned to the folder, to their case?
There should be.
As a result of locating that folder at your home, did you allow us to take custody of it?
I did.
And can you tell the jury, was there an empty manila file folder within that brown accordion folder that we asked you some questions about?
There was.
And can you tell the jury the label for that empty file folder was what?
I think it was LWT Diane.
And LWT stands for what?
Last Will and Testament.
Would it have been for this time period after you would have begun working with the McIvers with respect to their wills, this 2009 time period?
I believe that that's when it would have been created.
And did I ask you some questions about why the manila file folder was empty?
You
I
did.
guess I object to, what did I ask you about this? I think the proper procedure is just pass the witness. Why was the folder empty? And here's the procedure.
Sure, and I agree. And depending on the answer, you then may need to bring everyone back to what was said when you were recovering those papers.
Yes, sir. Was the file folder empty?
The file folder was empty.
Were you asked as to why the file folder was empty?
I was.
And could you tell the jury, what did you say then about why the file folder was empty? That was marked Diane, Last Will and Testament, or LWT.
I think, so I still object about what were you asking?
Yeah, ask him
Yeah.
why was it empty?
Why was
And
it
if he well, just hold on so we don't repeat this. And if he says something in your mind, it becomes admissible and relevant what he said back then you can explore what he said back then. He's here to tell us now why was the file folder empty. So that's the question before you.
The file folder was empty There could have been a couple of reasons for that. Number one, it could have been during the practice then that when we got an estate planning client, that the folders would be made up for the people that we were making the folders up for in advance. That was the practice at one point. I can't tell you if that was still the practice at that point. So if we never did a will for her, then that would make sense that there was nothing in there to for that. But we may not have, we obviously had a copy of her will because it had been emailed to me prior to that point in time. Why it wasn't printed and put in there, I can't tell you. It could have been we did a shred project. It could have gotten shredded in that project. I did not physically handle those files. I had people in my office that handled those files and those documents for me.
And is that what you told us when we asked you about this, when we recovered the file? That it could have been lost in a shredding project in the office?
I think so.
Can you tell the jury, when did you learn of Diane McIver's death?
I can't tell you the date I learned of her death. But it was shortly, within days, I believe, after she died.
And you recall how you learned of her death?
You know, my recollection is that Tex McIver's assistant called me up and...
Don't tell us what she said. Because that's hearsay, okay? Were you about to say what she said?
But I don't object.
Really? Really? Okay, they don't object.
Okay, so I believe it was Tex McIver's assistant called me up and told me that Diane had died, and she was looking for, my recollection is she was looking for a copy of the document that provided whether or not she was going to be buried or cremated.
Okay. What date did the assistant for Mr. McIver call you and ask whether or not Diane wanted to be buried or cremated?
That was that phone call I just described to you, I believe, and I don't know what date it was. I said it was after a couple days. I believe it was a couple days after her death. Maybe it was sooner than that, based on that question.
Okay. Did you have a copy of Diane McIver's will to be able to look at it to provide that?
No, I was like going, God, I must be really losing it, because I don't think that we ever did their wills, and we tried and tried and tried, and I don't think I ever got those documents. I will go and look, but I don't think I did those.
And is that what you told the assistant?
That's what I told the assistant.
And did you check your home file that had the empty file folder marked Diane LWT before you told her that?
No, I may have been in the car, and I said, I'll check, but I don't think that I did.
Okay. Can you tell the jury, when did you or did you speak to the defendant after the death of his wife?
I did speak to him, and it was, I don't know, maybe a couple days after that. I can't remember.
A couple of days after?
My conversation with his assistant.
Okay. And can you tell the jury, during your conversation with the defendant, did he ever tell you any of the details of what happened in the SUV that night during the shooting?
My recollection is that he did not.
Let me show you an exhibit. It's State's Exhibit 435. See if you can take a look at this and recognize it as an exhibit that highlights your phone number and phone calls between yourself and the defendant.
Well, the 5338, I believe, is the last 4 digits of my cell phone number.
Okay, the last 4 digits of your cell phone number are what?
5338.
And do you see any phone calls between yourself and Mr. McIver in that phone log?
Yes, 16.
16 phone calls. I would tender states 435, Judge. Admitted. Can you tell the jury what is the very first phone call between yourself and Mr. McIver?
9/27/2016.
And what is the time of the call?
It says 11:36, but it doesn't say. I assume it's AM.
And can you tell the jury how long did the phone call last?
Well, I think what it's saying here is 10 minutes. I don't know what that.
Okay, that's okay.
It says 10, 40, and 13.
Let me help you out. Put it on this screen, Mr. Hudson, that way. 9/27/2016, right?
Correct.
And this ET is kind of the elapsed time or estimated time, 11 minutes, 36 seconds.
Okay, that's not the time of day.
And this time right here, 10, 40, and 13 is the time.
Okay.
10 a.m.
Oh, okay.
Okay? And so there are phone calls all throughout the next couple of months, all through October, November, and December, correct?
Yes.
Okay. And in any of those phone calls, were any details ever relayed to you from the defendant about what happened on the inside of the SUV?
My recollection is no.
Were there any discussions with you about whether or not you had a new will for Diane McIver?
Absolutely not.
Do you have a new will for Diane McIver?
Absolutely not.
Have you ever seen one?
Well, I've seen it. I don't know what you mean a new will. I've seen a 2006 version that I gave you.
Okay. But you have not seen a will after 2006?
No, we did a codicil, and it was also in that file that was done sometime at the end of 2009 or 2010. You've got it in there, and that was sent to Ken Rickard and to Diane, and I don't believe that was ever executed. I believe Tex's codicil was executed. Absent that, the answer to your question is no.
As far as you know, Mr. McIver signed his codicil. And in quick layman's terms, what is a codicil?
It's a amendment, change to your will.
Okay. And the change that you proposed and sent to Mr. McIver and Mrs. McIver was as to what year's will?
2006.
Okay. And your recollection is that Mr. McIver signed his?
Yes, I believe it. You got a copy of it.
And Mrs. McIver did not?
I don't believe that she did, but you could ask Ken Rickard.
Yeah. Hold on just one second, Judge. Okay. Let me hand you this file folder. I just want you to take a look at it, see if you recognize it, can identify it. Then I'm going to ask you a couple of questions or so. Okay?
Yes, I recognize it. And I can identify it as the McIver bucket file is what I call it, that was in my house, and I gave it to you or somebody on your team.
Okay. And within that bucket file is where we found the file folder, correct?
That's right.
Okay. And is there a particular client number assigned to the McIver?
2786 is their client file.
Okay. Don't intend to tender any evidence. Judge, it's kind of large. I don't intend to tender any evidence, but I did want to identify. Okay. take a look at this exhibit, State's Exhibit 443. Do you recognize it? Can you identify 443?
This is a document labeled First Codicil to the Last Will and Testament of Claude L. McIver III. And it says that we're going to amend his will dated December 6, 2005. That's it.
Do you recall that to be the codicil that you previously testified to that was ultimately signed by Mr. McIver?
I believe that this is the one that was signed. I mean, I think it was. I think there was a signed one in that bucket file.
Okay.
Or I thought that I'd given you.
Let's see. From your recollection, do you know the codicil, the changes to Mr. McIver's will? What did they involve?
Well, I'd have to look at the other will, but it says here that
But I had to put it in the evidence yet, so if you just read it silently to yourself.
Okay, I got it.
Refresh your memory about what changes to the will Mr. McIver wanted to make for his 2005 will.
Got it.
Okay?
Got it.
Is your memory refreshed about what changes Mr. McIver was actually making to his will?
I read what's on this page, but to tell you what the changes are, it says here, I delete item 3 of my previous will, and now I'm going to do this.
Stop. Hold on. Let me do it this way, Judge. I'm sorry. Let me do it this way. Take a look at that exhibit. That State's Exhibit 444.
Okay.
Okay? Look over the last page. Appear to be the original.
It does.
That's signed
It is.
by whom?
Claude L. McIver III,
On what date?
December 30th, 2009.
And can you tell the jury that's a codicil?
This is a codicil. It's the one that you and I were just talking about.
Okay. And it makes changes to Mr. McIver's will.
It does.
Okay. Can you tell the jury, well, first of all, I will tender State's Exhibit 444 in the evidence, Judge.
So 443, we're not worried about it anymore.
This unsigned copy, okay, I will draw it
All right,
for the record.
444 is in evidence, and what I was hearing Mr. Hudson say is tricky, is that he was saying, well, some of the changes are, I delete some provision, and if he doesn't have the will in front of him, he can't tell you the significance of what's being deleted.
If you take a look at State's 444, are you able, by reading the codicil, to determine what changes Mr. McIver made to his will in 2005?
It's difficult to answer that question because it says I delete this item, and I know what the new provision is because that's what the new provision is. I delete this in my 2005 will, and I substitute this.
Okay.
So sitting here right now, I can't tell you what item 3 of his 2005 will says.
Okay. Could you tell the jury what is the new provision that Mr. McIver wants inserted into his new will?
It's a provision that says if Diane S. McIver survives me, she gets all of my interests in the farm in Putnam County and all the furniture and fixtures, livestock, everything with that if she survives me. It also says that if Diane McIver survives me, I give her my interest in McIver Enterprises LLC to her if she survives.
can you tell the jury, does that change to Mr. McIver's will that he signed in 2009, does it make any contemplation of what happens if Mrs. McIver dies first?
Not to his will.
Right. So let me just ask you this. The changes that Mr. McIver made in that codicil, does it in any way leave an interest in the ranch based on his codicil to Austin Schwab?
Does it, this codicil doesn't. This codicil only speaks to if she survives, this codicil saying, if Diane survives me, Tex McIver, then she gets the ranch and she gets McIver Enterprises LLC. It does not say what happens if she does not survive Tex.
This is States 445. You recognize States 445?
I do.
What is it?
This is Tex McIver's last will and testament that was prepared by the attorney that worked on his Stan Smith prior to me doing work for them.
Is that 2005 will?
It says 6th day of December 2005.
Okay. And that is the will that is referenced in the codicil from 2009.
That's correct.
Tender States 445, Judge Evans.
Committed.
And for completeness, could you tell the jury what is the paragraph that was taken out of the 2005 will?
It was a paragraph that left, I give, devise, and bequeath my farm and all the furniture, livestock, etc. to Diane, was Landa Diane Smith if she survives me.
And so what's the difference between the 2005 will and the 2009 codicil?
The difference is that that exact sentence is in the codicil, and the addition is that he also gives her McIver Enterprises LLC
Okay.
if she survives him.
Okay. And the codicil, the change to the will, if Diane McIver does not survive Mr. McIver, is there any provision in the codicil for the ranch to be held in trust for Austin?
No.
Did you prepare Mr. McIver's 2016 will?
I did not.
My last question is, do you know who did prepare his 2016 will?
I didn't know he had a 2016 will.
Okay. All right. Thank you. That's all my questions. Thank you.
All right, Mrs. Clark Palmer, approach slowly just so the jurors can stand up. Do a little hokey pokey before you start your cross-examination of Mr. Hudson, and we'll see where we get. You need to stand up, Mr. Hudson. All right.
Okay, I apologize, Judge. One more exhibit. Mr. Hudson, this is States 446. Understand there's no objection. If I could just have Mr. Hudson really just identify what that document is.
It is what is the last will and testament?
Just speak up a little loud, sir.
I'm sorry. It's the last will and testament of Claude McIver III, and it's dated March 16, 2004. Again, I believe that the attorney Stan Smith prepared this. Behind that is another document, a durable power of attorney, general durable attorney by Claude McIver, and that document is dated also March 16, 2004.
Okay. And would you have had both of those wills in your... Okay. Then I would tender, understand there's no objection, states 446.
Which is what
Yes.
I could for shorthand call the 2004 will, correct, opposed to the 2005 will.
Correct.
Or the 2016.
That's correct. Yes, sir.
No objection?
Correct, no.
Okay, so two of them are in. 2016 is not, but 05 and 04 are both in.
I think 2016 came under a different list.
But it's not right now.
And not right now, but it came in with a different way. Okay, yes. And that's all my questions, Judge.
For real? Ms. Clark,
All right.
you're with.
Thank you, Judge. And good afternoon, Mr. Hudson.
Good afternoon.
I'm Amanda Clark Palmer. I don't think that we've met before. Who knew wills and estates was going to be so thrilling and exciting, right? Okay. Let me start with the ranch and the way it was owned. You told us you, in addition to preparing wills and giving people advice about their estates, you also have knowledge and do things that are related to real estate transactions.
Correct.
Okay. And the ranch here, there's a deed that goes with property when people own it, correct?
Correct.
And you look at the deed to tell you, well, how does this person own the property, right?
Right.
Okay. And there are different ways that two people can own property.
Correct.
One of the ways they can own it is as joint tenants with rights of survivorship.
Correct.
All right. And when you own it that way, as joint tenants with rights of survivorship, myself and my husband own a piece of property as joint tenants with rights of survivorship. If my husband passes away, I am now the only owner of the property, right?
Correct.
The property doesn't have to go through his estate, correct?
Correct.
In fact, it's not that it doesn't have to go through his estate, it's that it doesn't go through his estate, correct?
It is not part of his estate because it's like a contract that you and he make when you acquire that property, and you to agree that it's going to be held as joint tenants with rights of survivorship. Then it's like a contract. You say, this is what's going to happen. I don't care if you have a will. I don't care if you don't have a will. When first of us dies, it goes 100% to the survivor.
And so if, in this situation, if Ms. McIver had said in her will, I leave my interest in the ranch property to Mr. Hudson, even if that was in her will, because she owns the property as a joint tenant with rights of survivorship, the court would just look at that will and go, I don't care what you said in your will, because now Mr. McIver is the only person who owns this property.
That's right.
Okay. And if you want to, if Mr. McIver and Mrs. McIver wanted to change the way they owned that property, they would have to do it together.
Yes.
Ms. McIver couldn't go down to the courthouse and, well, strike that. Let me ask a better question, as opposing counsel would say. They were contemplating making changes to how the ranch was owned, right?
Yeah, I'm not sure they were contemplating it. In the course of the planning that we were doing, we were suggesting that it be held in a different way.
That it be held by a company,
Yes.
and that both Mr. McIver and Mrs. McIver were going to have equal interest in that company.
Yeah, I'm not sure that we got that far because we had a question on on whether or not you could hold the LLC interest as joint tenants for rights of survivorship. At that point in time, we had a question about it, and I know that the other attorney, Ken Rickard, and I that's one thing that we were going over.
And they were looking at that in part for tax purposes, right?
Correct.
Trying to minimize their tax burden.
Well, there was two reasons, really. I think, as I recall, the goal was to try to get the property held in a entity like an LLC that would have its own income tax return and its own activities, as opposed to being on their personal income tax return. The accountants and myself, but it's more so the accountants were of the opinion that that would be a better way to maximize the income tax deductions that were available. And the other thing that we wanted to do was the asset protection planning aspect of it. If somebody was injured out there, or they had cattle, livestock, and a cow were to get out of a fence and wander out on a road, then they could be held liable for it. So, or somebody they entertained out there, somebody were to go out there and get injured. So that would have also helped with that liability aspect.
Okay, and there's nothing wrong about trying to maximize your tax deductions, correct?
That's my understanding.
And people seek that kind of advice all the time.
They do.
Okay. And in all the time that you were working with the McIvers, the ownership of the ranch never changed from joint tenants with rights of survivorship.
That's my recollection, but I believe, I can't recall, but I believe that we may have, prepared some deeds that would have transferred this to one of the entities or to a different form, but that's my understanding. It never changed.
Okay. And sitting here today, you haven't found an email or some document that changes your recollection about whether or not the ownership of the ranch ever changed?
No.
Okay. And so since you mentioned Ken Rickard's name, Mr. Rickard is a lawyer, correct?
Correct.
And you were dealing with him on behalf of Diane McIver?
Yes.
He was representing Diane?
Well, we weren't adversaries, and we were trying to figure out the best way to do this stuff. And so but yes, he had been representing her before, and there were some leases and some other machinations that we were going to be going through, and so he was looking over those. So he was representing her, sorry.
Okay. And you said it wasn't adversarial, this
No.
this process that you all were going through?
No, it was collaborative.
Okay. And in fact, Miss McIver didn't have to use you to change her will if she didn't want to, correct?
That's correct.
Okay. And there are a lot of other lawyers in Atlanta who draft wills, correct?
There are.
And there's no legal reason that you know of that she couldn't go to some other lawyer to change her will?
There's no legal reason that I'm aware of.
Okay. And you were having discussions with her lawyer, Mr. Rickard, correct?
Yes.
Okay. Discussions and negotiations, or just discussions?
Well, there weren't a lot of discussions. They're mostly just emails back and forth, correspondence back and forth.
And he was giving you his input?
Yeah, I believe he was.
Okay. And in 2009, we went over the codicil that you prepared for Mr. McIver. And I believe that the state asked you whether or not there was any reference to Austin in that 2009 codicil, and there is not, correct?
There is not.
Okay, but the codicil, do you still have it in front of you? All right, what is a codicil? Just kind of...
A codicil is an amendment to a will or a change in a will. They used to be used a lot when you had to type wills and all legal documents. They really don't get used very much anymore. I mean, if there's something tiny in there, because most wills now are done electronically and we save the original, we just go in and just do a new will. But it's a codicil.
Okay, and it makes a change to an existing will?
It does.
Okay. And in this codicil, Mr. McIver is saying, I want to leave any rights I have in McIver Enterprises to Diane. That's one thing it says, right?
If she survives me.
And it also says that I leave her, kind of in plain English, I leave her the ranch if she survives me.
Correct.
Okay. But moving forward to 2011, there were conversations about making changes to the will of Diane McIver and Tex McIver to include Austin Schwall, right?
I think, but you probably have an email and you could refresh me on it.
Yes. Make sure I get the number. Instead of refreshing your recollection, maybe we can just read it.
I put all of them back in and it's not marked. I didn't do it.
Okay. All right, so I believe this is 147-16, which is in evidence. And this is okay, so it's an email from you on July 1st, 2011, right?
Yes.
To Tex McIver, right?
Correct.
2011 occurs after 2009, right?
Last time I checked.
I'm sorry?
Yes.
Okay. All right, so you're recapping the changes that you all discussed. And what you say in your email is that in Diane's will, item number 3, the farm passes to Tex, but if he is not alive, it passes into a trust for Austin, correct?
That's correct.
Okay, and 4 talks about the content of the Atlanta condos going to Tex, but if he's not alive, going to Austin's trust, right?
Correct.
Same thing for DRS investments, right?
Yes.
Going to a trust for Austin.
Correct.
Austin is mentioned in some of these other line items in your email, right?
Correct.
Okay. And then under Tex's new will, item number 3, he says the farm passes to Diane, but if she is not alive, it passes into a trust for Austin, correct?
Correct.
All right. So in 2011, you had discussions with Tex McIver and Diane McIver about incorporating Austin into both of their wills.
Right, I think what that email says is I was recapping a meeting that we had, and so that is my practice. We have a meeting, and then I send out what I heard at the meeting to make sure what I heard is what everybody else heard or thought, because it often sometimes isn't, and I just wanted to make sure that was it.
Right. And we went through some emails, and we saw some emails where Diane McIver and Tex McIver talked about not agreeing on those proposed changes to their wills, correct?
On those proposed changes?
Right. Well, just they were having a disagreement on the proposed changes to the will. They couldn't agree on how to revise their wills.
After we had that meeting, I can't remember that they had a disagreement. We had a meeting, and I wrote those things out.
Okay, but we went through some emails where they were having a disagreement,
Yes.
correct?
Yeah.
Okay. Diane wanted the ranch to go to Austin, right?
she ultimately wanted that ranch to go to Austin when she died. I mean, I know after they were both dead, they were both deceased, that she wanted the ranch to go to Austin. Based on what I've seen.
Okay. But we've already established that with the way the ranch was owned, she couldn't leave the ranch to Austin upon her death, correct?
No, it was held jointly, and that was going to go to Tex.
Okay. So if she wanted to leave the ranch to Austin, there needed to be a change in ownership to the ranch, correct?
Unless Tex died first.
Okay. Same thing is true for Tex McIver. If he wanted to leave the ranch to Austin, and I'm saying assuming that he died before Diane, if he wanted to leave the ranch to Austin, there needed to be a change in ownership to the ranch.
I think that what they agreed on was that after they're both deceased, then it goes into a trust for Austin. After they're both deceased is what they're saying there. So I don't think that, my recollection is not, they didn't have a problem with leaving the survivor the ranch. The issue was, where does this go after we're both deceased?
Okay. And they wanted it to go to Austin.
Based on that email.
Okay. But just to make sure I'm clear, because maybe I didn't ask a good question, but I was trying to ask a slightly different question.
Okay.
Mr. McIver, if he passed away before Diane, he couldn't leave anything in his will regarding the ranch to Austin unless they changed how the ranch was owned, right? Because the ranch doesn't go through his estate.
Right.
Okay. And if Diane didn't like the changes that were proposed to her will, there was nothing wrong with her going to some other lawyer and drafting a will with some other lawyer, not you, right?
That's correct.
Okay. And in fact, you told us she had Ken Rickert, who was acting as her lawyer and having discussions with you, right?
That's correct.
Okay. If Diane had called you up and said, I want to make an appointment to come in and see you, you wouldn't have said to her, well, you have to go through Tex first. Only Tex can make appointments with me, right?
That's correct.
Okay.
But I would have said, hey, what we're doing here is all one thing. I can't do anything with somebody on the side and the other person not knowing about it.
Because you represented both Diane and Tex, right?
Right.
So they both could have gone to some other lawyer.
They could have.
Okay. That was an option for them, right?
Yes.
Okay. All right. And so let me ask you just a couple questions about the will. In Tex's will, well, let me first ask, do you have to name an executor in your will?
You should. You don't have to.
Okay, so let me stick with you should. If you name an executor in your will, does that executor have duties and responsibilities that they have to carry out with respect to the will?
They do.
Okay. And one of their duties is they have to marshal the assets of the estate, correct?
They take an inventory of the estate. They've come up with all the assets of the estate, bank accounts, real estate, personal effects, equipment, cars, automobiles, everything that is a piece of property that's in the estate. And they find out what the debts are. Do they have medical expenses? Do they have credit card bills? Do they have mortgages? Those type of things.
Okay, so you said they're supposed to, ideally they make an inventory of what the estate has, correct?
Yes.
Which you said includes bank accounts, right?
Correct.
But also includes personal effects, right?
Jewelry, furniture, valuables, art.
Clothing.
Clothing.
And then they have to figure out, okay, what debts does this person have or the estate has, correct?
That's right.
Okay. You have to pay taxes, don't you?
Occasionally. I mean, what kind of taxes are you talking about?
Well, if somebody dies, when somebody dies, you have to make sure their tax return, their income tax.
You got to make sure their income tax return is filed and whatever income they had for the last year's reported, and then they get deductions. So they have to file an income tax return. They may not owe any taxes. And there could be estate taxes if the estate is large enough.
Okay, and then you have, there's an order of priority that people get paid out of the estate, correct?
Yes.
Okay.
Creditors get paid before beneficiaries get paid.
Creditors, people that the estate owes a debt to are creditors.
Income taxes, all taxes, property tax, Visa, American Express, mortgage company.
You have to pay,
personal debts.
Okay. You have to pay those, the executor has to pay those before you can pay off any bequests that are in the will.
Generally speaking, yes.
Okay. And bequests that are in a will are not suggestions to the executor, correct? It's not, hey, if you want to, you can pay $5,000 to...
Most of the time, they're made out as mandatory. I want X number of dollars to go to this person. In that case, they would do that.
And
they have to do it.
The executor has to pay that bequest if there's money left in the estate, right?
Correct.
Okay. The purpose of a will is to let the deceased person's wishes be known after they die, right? As to how they want their estate to be carried out.
Correct.
Okay. You don't tell your clients that they should hide their will and not tell anybody where it's located or what's in it. That's not advice you give them, is it? Okay. Because you want to be able to find a copy of the will when somebody dies, right?
Yes.
So you can carry out their wishes?
Yes.
Okay. Do you keep a copy of, if a will is executed at your office that you prepare, do you keep a copy of it?
In most times, we actually keep the original of it.
Okay.
And then we send a copy to the person who has their will on it.
And that's part of your practice, just how you run your business?
Yep.
How do you know which one is the original?
What's the last one in time?
Well, I just mean, if you look at a piece of paper, how do you know, oh, I've got the original will here?
Well, you can tell.
How?
Blue ink right there. Now it's a little bit tougher because we have copiers and scanners that can do all sorts of colors. But, if I had to, I could probably smudge it right there.
Okay.
And you can tell, we don't, it's getting better and better now to where copying and scanning is getting better, but it's not always been that way. You used to be, you could have a line over here, so you could tell what a copy, used to be you could tell easily what a copy is. It's a little bit tougher now.
And when you were giving us information about that brown
legal
file,
folder,
yes. I didn't understand what you were telling us about the labels on the file folders. Do you have standard file folders that you create every time you get a new client?
It used to be that I used to do a lot of estate tax planning and a lot of will planning. And so it was, that was a big part of my business. And so it used to be at one point that when we got a new client, you and your husband, we would get a file, put a number on it, sign you the next number in the order, put your name on it. And it used to be that we would do, and we always do the same documents just about everybody. We do an engagement agreement, we do a will for you, a will for your husband, a living will for you, a living will for your husband, a medical power of attorney for each of you, and a general power of attorney. So there may be about 10 folders in there. And at one point, we were making those up when we went along and did that. We stopped doing that.
Okay, you said at one point we were making those up as
we would make those folders up as when we got to you as a new client, I'd give it to somebody in my office, and they would get a folder out and, you know, assign a number to you and your husband, and then they would make up all those folders in anticipation of getting those documents signed and then putting them in there.
Okay, because you know it's probably likely at some point you're going to be creating a document that would go in one of those folders.
That's what I just said.
Yes.
Yes.
Yes, okay.
That was the reason for doing it.
Oh, I'm sorry, I can't help myself. Sometimes I just have to rephrase and repeat, but I'll try not to. Okay, so before you got those, pulled those documents out of your house, you had gone down and talked to the grand jury, you told us, right?
Yes.
Okay, and before you went to the grand jury, you spoke to Steve Maples.
Correct.
And Steve Maples was representing Tex McIver at that time.
Correct.
And you called Steve Maples, or he called you?
I can't remember.
Okay,
but anyway, I had made a point that I needed to talk to him. I mean, I may have talked to Tex, I don't know, but I made it a point to talk to Mr. Maples to say, I've been subpoenaed to come down there and bring my client's materials down there. Am I okay to do that? I have a client attorney confidence that I'm not supposed to turn their documents over to anybody. And so I didn't really know the rules when it came to court subpoenas. I just asked him if it was okay, or tell him what was going on. And he said, yeah, go ahead. I do believe I then said, will you please send me an email that says that?
Okay. And at that time you had gotten a subpoena for you to come testify, but also looking for certain documents that the DA's office wanted to see?
I can't remember what exactly the subpoena said. I'm sure there's a copy of it around here somewhere, but I know I was supposed to go down and...
But my question is, you knew they were looking for documents that you may have prepared in relation to Mrs. McIver's will?
Yes.
Okay. And you talked to Steve Maples, and he said, yes, go on down and go talk to the grand jury. If there's a privilege, we waive it, right?
Yes.
Okay. You weren't calling Mr. Maples to say, what should I tell them? What does Tex want me to say? You just wanted to make sure that ethically it was okay for you to go down and talk to the grand jury.
Absolutely.
Okay. And so what document, was there ever a document in the empty file folder that said LWT?
I don't know. I mean, there's a folder right over there. I can't remember exactly. That's what it said. But was there one in there? I can't answer that question as I explained earlier, but when I gave it to Mr. Rucker and his team, there was none.
Okay. If there was a document in there, is it possible that it was the 2006 will of Diane McIver that you had been sent via email?
That would have been the only thing that it could have been, because based on going through all my emails and electronic correspondence, which I'm sure everybody here has already gone through,
right,
that would be the conclusion, that there was not one created, at least on my server or on my emails. So yes, that is the conclusion.
Okay. And you told us that you never prepared a new will, new after 2006, for Diane McIver that was executed, correct?
Correct. I prepared a codicil, which I do not believe that she signed, and I sent to Ken, she and Ken, I believe, but Tex did have one, and he signed his.
Okay. But you didn't?
Subsequent to that, I have no knowledge that I prepared a will. I sent an email on July the 1st, I believe you just said it, and I said in that email, here's a recap of the meeting. And that email was to Tex McIver and to Diane McIver. And I said in that email, and I believe it to be true, here in July of 2011, here's a recap of our meeting. I can't recall on the day before that email if I met with them, but that would be what I suppose happened. Here is an email. Here's what we discussed. Diane's will, Tex's will. Let me know if you agree, disagree, whatever. Let's get these daggum things done.
Right. You never destroyed a new will of Diane McIver's, right?
No.
Okay. Tex never called you up and said, please shred that new will that she signed, right?
No, and if he had, I would have told him to go jump in a lake.
That's right. Thank you.
Mr. Rucker, anything on redirect?
Yep.
You have a few minutes.
Okay. So in response to Ms. Clark Palmer's question about the empty file folder, she asked you whether or not it was possible that Diane McIver's 2006 will could have been in that file folder, right? And you said yes, it's possible.
2005 or 2006, what was the year of her will?
2006. And I'll answer that question for you.
Yeah, it's possible.
You said it's possible.
Yeah.
Okay. So when you got the phone call back in September the 26th, I think is what you said, or the 27th of 2016, from Tex McIver's assistant asking you for a copy of Diane's will, I thought you told us you didn't have it.
Not following.
Okay. Could you answer the assistant's question?
No.
Right. And is that because you didn't have Diane McIver's 2006 will?
No, I didn't think that I had it.
Right. So when I came to see you 6 months later, and you gave me that file from your house and it was empty, Diane McIver's 2006 will had never been in there, right?
I don't know that.
You said you talked to Steve Maples before you came to see me at the grand jury, and he said, hey, you know, it's okay, go ahead and talk to him.
That's right.
You knew my subpoena. I was looking for any will that belonged to Diane McIver, right?
That's correct.
Did you bring any documents whatsoever?
I did not. I did not.
Why not?
Because I looked in the electronic file and I didn't see one in there. But after I came, I looked in all of my emails and started going back through everything that I had. I should have done a more thorough job. I was convinced I didn't have it, didn't have anything. But once I found them, I emailed you, I believe I emailed your assistant, and then later that morning and said I had these documents, and I believe later that morning you came to my office and I gave you a set, and I also gave for the first time Mr. Maples, or was going to give him a set.
Right. Did you also tell them what your testimony was before the grand jury?
I did.
You told them exactly what you told the grand jurors?
I don't think I told him exactly what I told the grand jury, but he asked me and I told him.
Okay. At the time that you told him, did you know that grand jury proceedings are supposed to be kept secret?
I did not.
Now, is there a rule that said...
I'm sorry for my belated objection, Your Honor, to Mr. Rucker's question, because I don't think it fairly reflects what the rules are about grand jury proceedings for witnesses.
Okay.
So I would ask to strike the question and the answer and ask the jury to disregard.
Mr. Rucker, well, Judge, I don't want to speak in front of the jury, but I do have a response to that.
Okay.
If you want to make some instruction, it's fine.
What I'll do is let you and Ms. Clark Palmer talk about that with me when we're done with Mr. Hudson, and if I need to let the jurors know they should disregard or consider something differently.
That's fine. Yep. Let me ask you this. Is there a rule that says you have to pay bequests or bequests in a will like within a few days?
No.
Is there a rule that says, hey, when there's a bequest in the will that pays somebody some cash money, you have to sell the deceased persons all their jewelry and stuff immediately so that you can pay off the cash money bequest?
Object to being argumentative, Your Honor, and leading.
I don't think it's leading, and I'll allow this one, but in general, just sell property to. Do you understand the question? Should he repeat it?
Is there a rule, I'm sorry.
Yeah, is there a rule that says that if you got to pay somebody some cash in a will, in a bequest, that the deceased person's property, all their property, needs to be sold, gathered up in inventory, and taken to an estate sale and sold so you can pay off that cash money bequest?
There is no rule that I'm aware of.
Okay. You said earlier to Ms. Clark-Palmer that we wanted to change the ownership interest in the farm. Who is the we?
Well, it would definitely be the advisors.
Okay.
It would be Twiggs Kelly, myself, I believe Tex was a proponent of it, and there was another accountant, Jerry Humphreys, and I believe that he was, he thought it was, I can't remember if he was involved in that time or not.
Okay. But the we does not include Diane McIver, right?
Maybe not initially.
No. She wasn't in favor of changing her ownership interest in the farm, was she?
I don't believe so.
And Ms. Clark-Palmer showed you this exhibit. It's 14720. It was all it's pretty much like you said, it's a recap of the meeting that you would have had with Diane McIver and Claude McIver discussing changes to the will, right?
Correct.
And you listed out a bunch of bullet points for Diane's new will, right?
Correct. Yes.
And then there's also some bullet points for the defendant's new will, right?
Correct.
So this email that you said you sent out to make sure that you heard what was said at the meeting, you sent it to who?
Diane and Tex.
And this would have been right after the meeting?
I believe what it says, I'm writing the recap of our meeting last night, and so I sent it the next day at 5:30.
Okay. And then the response you got back to you on April the 4th is...
August the 4th.
I'm sorry, August the 4th. Thank you. That was about a month later?
Yep.
Okay.
Yes, sir, I'm sorry.
That's all right. The response you got back from Diane McIver is, I'm still having a problem with Javier's deal, right? ...
Correct.
Item 14, what was the deal for Javier?
Javier Hernandez can live on the farm, earn the current arrangement as long as employed, but if not employed, he gets $100,000.
She had a problem with that, right?
That's what it says.
She also says Austin's age should be, in this question mark, I would like to talk about that. Is there a better age to give to him, right? Yes?
Yes, sir.
This was in 2011. Did you know Austin had been born in 2006? Did you know?
I didn't know that he was born in 2006.
Okay.
I mean, somebody could have told me back then he was born in 2006. I don't remember right now that he was born in 2006.
Okay.
But I knew that he was a boy.
Okay. She also said, what happens if both of us die together? What happens to the ranch? That was her response back, right?
Yes, sir.
Okay. She also responded back and said, why does Robbie get my wedding ring upon my death? Right?
That's exactly what it says. Why does Robbie get my wedding ring upon my death? Question mark.
And why is my trust paying for Texas education at this time of his life? right?
Correct.
So when this email was written in 2011, fair to say you guys were no closer than y'all were in 2009 to getting the wheel done, right?
I would not say that was fair to say. I would say that after I met with them and wrote my email, I thought that we were pretty close to getting one done.
Okay, well, did you get one done?
We did not get one done.
Not in 2012, 13, 14, right?
I have emails asking them, like you just showed me an email a while ago from 2014, seeing if we could get together.
Right. All right, thank you.
Questions from the jurors from Mr. Hudson? Pass those over and wrap things up. Where is the big red well? Hudson, a couple questions.
All right.
You had described to the jury several times, answering questions, that at one point in time it was a practice of your firm to create these standardized folders. I come in, I meet a client right away, they'd say McBurney will, McBurney power of attorney. Does the bucket folder that you have contain other of those standard document folders for Mr. and Ms. McIver?
It's got a correspondence file, which is a standard one. It's got a Tex McIver last will and testament.
You don't need to rattle them all off, but are you seeing other,
No. No.
were any of the other folders that you just mentioned empty?
They're not even in there. Like for a living will, a medical power of attorney, they weren't done.
So the collection of standardized folders that you were envisioning, not present in that folder?
No.
Okay. Mr. Roberts, any follow-up for Mr. Hudson?
Do you have a way, if looking at the bucket folder, can you tell, does it contain all of the contents that we were given when we got it from your home?
I have no way of knowing that. I mean, what I gave to you, and I'm assuming you kept it all in there.
Right, Paul, any questions?
I do, I think, if I can just some of these folders in here are empty. Do you know if that's the way it was when you turned it over?
I don't know.
Okay, all right.
I'm sorry.
I don't know. Sorry.
That's okay, you don't need to apologize. Thank you for your time, Mr. Hudson. You are free to go.
Thank you.
Ladies and gentlemen, we're done. Long day. Thanks you for agreeing to stay till 6. Juror 5, we're escalating your situation. Juror 61, you had asked for something from Ms. Hansberry, and I don't understand what it is you want.
The letter.
The letter for the days you've been here so far?
Yes, and submit the transportation so that they could be on time for it.
Okay, great. I just can't, the way I read it, I couldn't tell if you needed it going forward, and we don't know what days you'll be here going forward, but we can certainly get one for all the days you've been here. If that's what you're looking for, great, we'll take care of that.
We were going to talk before about something maybe to tell the jury.
We'll tell them in the morning. We'll talk, but I'm gonna let you guys go. Thank you for a long day, 9 a.m. tomorrow morning. Don't talk about the case tonight, I'm sure you wanted. No outside research. 9 a.m. tomorrow morning, we'll get rolling with whoever the state's next witness is, okay?
All right, for the jury. You may be seated.
Thank you, Deputy Kane. All right. If you want to talk to me real briefly about whether state grand jury proceedings are secret or not, I'm happy to hear on that. And then certainly if I understood the question that was asked and how that could create a misperception. I don't know the answer. I'm not disagreeing with you. I heard the never so quiet consternation of the defense bar when they felt that wasn't an accurate representation. So I'm not shying away from telling the jury that. Because I don't know the answer, and I have a federal background where that could have been a problematic situation, not necessarily. Because
I'm sorry, let me interrupt you. I'm sorry.
That's all right. I mean, what I don't know is the interplay between a witness's ability to do what a witness wants to do and a criminal attorney saying, talk to me about what went on in grand jury. On either side, a prosecutor, I don't know why that would come up, or a criminal defense attorney for someone who, but I don't know. And if you think it merits me explaining that to the jury, I'm happy to do it, lest they have a perception that Mr. Maples did anything inappropriate in asking Mr. Hudson. And I don't know that Mr. Maples solicited. It could be that Hudson volunteered.
I'm more worried about the jury's perception of Mr. Hudson maybe have done something inappropriate. The witness has no restriction on sharing what they testified about at the grand jury. There's a U.S. Supreme Court case, Butterworth versus Smith, 494 U.S. 624. There was a Florida statute that barred witnesses from talking about grand jury, and the Supreme Court said you can't infringe on the witness's First Amendment rights.
Okay. Is it your understanding that it is kosher for the attorney, for the person who might be the subject of the grand jury investigation to press witnesses to tell him what they discussed in front of a grand jury?
I didn't hear Mr. Hudson say that Mr. Maples pressed him, but I don't think there's anything wrong with the defense attorney saying, what did you tell the grand jury if you'll share it with me?
The fact that Mr. Harvey does it all the time doesn't ipso facto.
I do it too. I do it too.
You would
Oh,
not,
then it must be.
you would not be doing your job as a defense attorney if you didn't ask a witness, if you don't mind, share with me what you told other people.
Sure. Mr. Rucker, any reason why I shouldn't tell the jurors just when we get started in the morning? In case you remember this one exchange, you need to understand there's nothing wrong with a witness in a grand jury proceeding talking to people about what was discussed.
I had a good faith basis for asking the question. I'm just going to ask you if you give it to in the morning to look up Mr. Samuel's site.
Sure.
And I can shoot everybody an email tonight and let you know.
You just tell me in the morning. It'll be first thing we talk about in the morning.
Yeah.
All right, so I got an email a little before 5 from my staff attorney saying, Ms. Counts is saying that she was told by a DA's investigator she had to be down here around 4:30 or 5 today. I see Ms. Counts. Hello, Ms. Counts. I don't recall telling anyone that we were going to stay after 6 o'clock. So I'm frustrated on behalf of Ms. Counts that she came down here to talk. We have a court reporter who has worked overtime, and we're not going to be able to get into a full-throated discussion about what, if anything, we're going to do. Ms. Counts is handling Mr. Diggs and Ms. Hobbs. If she wants to send the DA's office a bill for her time that she had to spend down here this afternoon, I'll stand behind the bill because I didn't envision that we'd have time to talk, not because I'm trying to be scarce or difficult, but it's 6:15.
I get it, and it's in her frustration. Please put it on my shoulders. If you want to send us a bill, I'd be glad to sign off on it. It was my mistake. I had been anticipating that we would end at 5 today. I don't think either side knew that we were going to 6 today.
I appreciate folks are in and out. We actually asked the jurors pretty early on today, because today is 6th day, and they said 6.
Right.
And I pushed that out.
You did, and I said it's my fault.
Okay.
In the heat of what else was going on today, I did not properly make any adjustment to prevent Ms. Counts from coming down, and so I apologize to have you come down. It was just my anticipation that we finish at 5, and perhaps because I anticipate those witnesses coming up in the next day or so, and I just wanted the court to be in a position to.
I appreciate that, and when we stop at 5, I'm happy to ask the court to stretch a little bit past 5.
It was my fault, and I apologize.
So we'll start tomorrow with a quick update from Mr. Rucker's legal team as to whether they have a reason that we should just leave alone the question about grand jury secrecy and Mr. Hudson. Otherwise, I'm inclined to give an instruction to the jury that they shouldn't view that as in any way inappropriate or sinister or underhanded, adjectives. And then we're going to go on with the state's case. Anything else from the state before we break? No. Okay. Anything from the defense? Okay. Thank you, everyone.